गुड मॉर्निंग सर।
गुड
मॉर्निंग
मॉर्निंग।
मैम, कैसी हैं?
आई एम गुड। जस्टिस सीकरी इज आल्सो हियर।
ओह,
या
गुड मॉर्निंग लॉर्डशिप।
गुड मॉर्निंग। गुड मॉर्निंग।
वेलकम योर लॉर्डशिप।
थैंक यू।
योर बैकग्राउंड इज वेरी गुड।
ओके, थैंक यू।
Good morning, everyone. Uh, Sir, can we start or should we wait for 5 more minutes so that all the participants could join?
How many participants have already joined?
Sir, we are 13 number right now.
We can wait for a few minutes, no problem.
Okay, lordship.
Thank you, sir.
Okay, lordship.
All OC members and participants are requested to please switch on their cameras. We are about to begin.
Good morning, everyone. We welcome you all to the workshop of the 6th edition of S.K. Misra Memorial International Mediation and Negotiation Competition 6.0. For giving the welcome address, I may now invite Dr. 𝐒𝐔𝐁𝐄 sir, Director, Lloyd Law College.
Thank you, Preet. Honorable Mr. Justice 𝐒𝐒𝐂𝐑𝐈𝐁𝐄, respected speakers, Ms. 𝐅𝐸𝐺𝐵𝐺𝐿𝐰, Ms. Linda Heng, Ms. Kathleen, and Ms. 𝐒𝐒𝐂𝐑𝐈𝐁𝐄, esteemed guests, faculty members, participants, and dear students. A very warm welcome to all of you. It is a great honor for us to host this workshop as part of 6th S.K. Misra Memorial International Mediation and Negotiation Competition 2025. As you are aware that mediation and negotiation are very important in today's world. Instead of fighting in a long legal battles, these skills help people solve problems peacefully. As future lawyers and professionals, learning how to negotiate and mediate effectively will help you make a real difference in society. We are extremely thankful to our speakers today, Honorable Mr. Justice 𝐒𝐒𝐂𝐑𝐈𝐁𝐄, who is a highly respected legal expert who has contributed greatly to the field of law and mediation. We have presence of Ms. 𝐅𝐸𝐺𝐵𝐺𝐿𝐰, Ms. Linda Heng, and Ms. Kathleen, and also Ms. 𝐒𝐒𝐂𝐑𝐈𝐁𝐄, who all are expert in mediation and negotiations. It is a great privilege for all of us to host this esteemed panel. I welcome all of you, sir, Honorable Mr. Justice 𝐒𝐒𝐂𝐑𝐈𝐁𝐄, Ms. 𝐅𝐸𝐺𝐵𝐺𝐿𝐰, and all other speakers. Welcome you for this workshop. I encourage all of you to participate, all the participants to participate actively, ask questions, and make the most of this opportunity to learn from the best. This workshop is not just about understanding mediation techniques, but also about developing the ability to resolve conflicts in fair and peaceful manner. Once again, I thank our esteemed speakers for joining us today, and I hope this workshop provides valuable insights and inspires all participants to explore the field of mediation and negotiation further. Wishing you all the best for the participation. Thank you.
Thank you, sir. Now, I would like to invite Samriddhi to give a brief introduction about 𝐅𝐸𝐺𝐵𝐺𝐿𝐰 ma'am, who would be speaking about S.K. Misra Mediation and Negotiation Competition today.
Ms. 𝐅𝐸𝐺𝐵𝐺𝐿𝐰 is Central Government Standing Counsel.
See, there are more than one devices at that place. That's why echo is coming.
Yes. Preet, can you
Ms.
ensure that?
𝐅𝐸𝐺𝐵𝐺𝐿𝐰 is Central Government Standing Counsel, Director at Lloyd Law College, and Chairperson Lima, and the Director of IIAM with over 18 years of experience in criminal, matrimonial, civil, commercial, banking, and finance matters. She is an 𝐴PCAM certified arbitrator, 𝐴PCAM international certified mediator, and IMI certified mediator. Ms. 𝐅𝐸𝐺𝐵𝐺𝐿𝐰 is the Executive Director of 𝐴PCAM and serves as a mediator with United Nations Development Programme, WIPO, Delhi High Court Mediation Center, and various international arbitration and mediation panels. She is also the co-founder and Secretary General of International Federation of Mediators in France and a faculty member of IIAM. A recognized leader in her field, Ms. 𝐅𝐸𝐺𝐵𝐺𝐿𝐰 has won the BIMAG Top 10 Mediators in Asia Pacific Awards and authored several books on mediation. She has judged in prestigious competitions such as ICC Mediation Moot in Paris and WIS East Moot in Hong Kong and Vienna. We welcome you, ma'am, to Lloyd Law College.
Thank you so much. I'm very good morning to all of you. Honorable Chief Guest Justice 𝐒𝐒𝐂𝐑𝐈𝐁𝐄, Director 𝐒𝐒𝐿𝐼 sir, and distinguished guests and dear participants. It is a great privilege to welcome you all to the opening of 6th edition of the S.K. Misra Memorial International Mediation and Negotiation Competition 2025. On this fine day, here it is, the morning, wherever all of you are joining in. This shows your dedication to this competition, rather the idea that we are building throughout the last 5 years. Let me begin by highlighting why this competition is unique. This competition tests your ability to negotiate and mediate effectively and challenges you to think critically, collaborate across cross cultures, and navigate complex dispute with a problem-solving mindset. It is not merely a competition. This is our revolution, a movement towards a world where mediation becomes the first choice in resolving conflicts. We come together today to build skills, exchange ideas, and develop a deeper understanding of how mediation can transform into cooperation. Each year, this competition has gained tremendous momentum, evolving from a small initiative to a prestigious international platform. I still remember the initial days when we started with a handful of participants, and now we have become a global gathering of almost 100 plus teams from the diverse backgrounds. This remarkable growth reflects the increasing recognition of mediation as a crucial tool to resolving dispute. Year after year, we have expanded our reach, welcomed new perspective, and refined our approach to mediation and negotiation. The dedication and enthusiasm of the participant, the organizing team, and the partner have been crucial in making this event a hallmark of excellence and alternative dispute resolution. Now, our mission is to develop alternative dispute resolution education and to prepare the future leaders who can integrate mediation into legal, corporate, and diplomatic spaces. And the mediation and negotiation are no longer supplementary skills, but essential competencies for professional navigations and increasingly interconnected world. The purpose of this competition goes beyond mere practice. It is about pioneering a change in how disputes are resolved. In India, mediation is still in its early stages and yet to be recognized as a distinct subject of study for the students especially. Through this platform, we strive to popularize the mediation and make it more accessible to the young professional, ensuring that future generation understand its value and embrace it as a primary method of dispute resolution and should not be as an alternative. The skill you develop here will extend far this competition, influencing your future career and personal interaction. Mediation is not determining winning and loser. Rather, it is about fostering understanding, developing creative solutions, and bridging divides. In conclusion, I would like to extend my sincere appreciation to our Justice 𝐒𝐔𝐁𝐄, who has taken his time to encourage you all. I thank you, sir. Our guests, sponsor, partners, and well-wishers, organizing team for their continuing support in making this competition possible. To all the participants, I wish you enriching experience filled with learning, collaboration, and growth. Let us make this opportunity to advance the practice of mediation and negotiation, shaping a future where conflicts are resolved with wisdom, respect, and mutual understanding. Thank you so much. Over to you, Preet.
Thank you so much, ma'am, for giving a valuable insight about the competition and also how does it play a significant role in the world of mediation today. Now, I would like to call Daksh to give brief introduction about Honorable Justice Mr. A.K. 𝐒𝐔𝐁𝐄. Sir will be dealing with the topic International Perspective of Mediation.
Honorable Mr. Justice 𝐅𝐨𝐥𝐿𝐿 is a distinguished jurist whose career spans over 4 decades. He completed his LLB and LLM from Delhi University's Faculty of Law. He enrolled as an advocate in 1977 and was designated as a senior advocate by the Delhi High Court in 1997. Justice 𝐒𝐔𝐁𝐄 was appointed as a judge of the Delhi High Court in 1999 and later the acting Chief Justice in 2011. He was elevated as the Chief Justice of the Punjab and Haryana High Court in 2012, before being appointed as a judge of the Supreme Court of India in 2013. Currently, he is appointed as judge at the Singapore International Commercial Court. He is also the chairman of News Broadcasting Standards Authority (NBSA) and Ombudsman, Indian Federation of Sports Gaming (IFSG). He has also been actively involved in academia and policy making, serving on various legal and public policy committees. His contributions to Indian jurisprudence remain significant, with over 4,700 reported judgments and extensive scholarly work in constitutional, commercial, and arbitration law. So, we welcome you to Lawyer.
Thank you very much for this generous introduction, which was not needed. And first of all, let me thank Lord's Law College for inviting me in today's function. And I must congratulate also at the same time Lord's Law College for organizing this competition. Actually, this, as I'm told and everybody knows now, that it is the 6th edition of this S.K. Mishra Memorial Mediation Competition. And I must, why I said I congratulate, but because it's a futuristic step, which the director of the law school, along with Iram Mazid, who have conceptualized it and thought about it 6 years ago. Let me say, let me tell you why I say so. I go back to my initial days in the practice, and I was just remembering that anecdote. I think it may be after 1 or 2 years of my joining the bar, I was in the High Court appearing before a judge, Justice H.L. Anand at that time. And I'm talking about this must be 80-81. And at that time, he was telling one thing which he told in the when we were there to the lawyers, he was addressing and telling that, look, 99% lawyers are coming to the court for 1% work, and 1% lawyers are doing the major work, which is arbitration, whether it is domestic or it is international arbitration. Because you go to the court, you keep waiting for your turn. It may come, may not come. So you whole day you have waited, your turn may not have come. And in any case, every day you wait for 1 hour, 2 hours before your turn comes, and then you argue and you go away. And he said that, look, arbitration is one field. If a matter is fixed and it is at 10 o'clock, it will start at 10 o'clock. You don't waste your time. And the way word is growing, and that is what I'm saying, he said in 1980s, early 80s, I'm saying the way word is going, this future is for arbitration. And therefore, people should be more and more advocates should adopt the practice of arbitration, and they should not be glued to courts only. And I found over a period of time that he was very right. And it was such a prophetic statement which he had made in 80s. Thereafter, when I was in the practice and I had been doing so many arbitration cases, etc. And then I saw as a judge the total paradigm shift in the arbitration practice, particularly after India ushered into this globalization and because of this, many the FDI is coming, foreign direct investment, and technology is coming. There are many collaboration agreements. So they gave rise to many kinds of international disputes also, cross-border disputes also, which I found 99% was domestic arbitration. That during my tenure as a judge only, I started perceiving it, or started noticing it, that there's a paradigm shift in the arbitration work. And after my retirement, when I now see the kind of arbitration which is going on, and I was remembering more than 40 years ago what Justice H.L. Anand said. And today I say that about mediation. That mediation is going to be the main profession. The way arbitration has grown, and mediation is going to beat even arbitration. In 2002, Section 89 was added, in our Code of Civil Procedure. It was inserted in order to have this mediation and conciliation and other means of alternative dispute resolution mechanism was provided, which even talks of judicial settlement, arbitration, etc. But even when somebody today talks about Section 89, everybody thinks about mediation and court annexed mediation. Because of that, all other forms were either already there or they were in vogue. But what was a new thing which was introduced was this mediation. And after this was introduced, there's one Salem Bar Association in Tamil Nadu which challenged the constitutional validity of this provision, because they did not want mediation to be there. And sorry, the perception of lawyers at that time. So this is 2002 matter comes, so I'm talking about 2004 or 5. So perception was that with the introduction of mediation, our practice will go away, as if people will settle the disputes outside the court and nobody will come to us. So ADR, when we talk of this alternative dispute resolution, they thought it ADR to be alarming drop in revenue for lawyers was ADR for them. So that was challenged. But I always thank this Salem Bar Association for filing that case. Not that they succeeded, they failed, which they were bound to, because the petition was dismissed. But what it happened, it brought the entire matter of mediation to the notice of the Supreme Court. That we in India, many laws are passed, but they remain on paper. And many times their activation or the proper implementations of laws, those laws, that doesn't take place. But that did not happen to mediation. Because of this case, I would say, and that is why I say I thank Salem Bar Association for filing that case, because while dismissing this case, the Supreme Court ensured that mediation takes off. So they immediately constituted a committee headed by Justice Jagannath Rao, who was the chairman of the Law Commission at that time, to frame the rules of mediation and court management and mediation in so model rules, and directed all the high courts to adopt those rules within 1 month thereafter, and then they followed it up also. They didn't normally judges give the judgment and thereafter it is not a case before them, but there was a follow-up, and that's why there was Salem Bar 2 also, the judgment where all these directions were given. And one thing more, if I may say, as I said, that the lawyers, if this judgment had come, no doubt, but the lawyers were still shaky. And the Supreme Court did one thing more in order to propagate, because for mediation, you need mediators who have to, lawyers would go there or parties would go there, but we didn't, it was a newly introduced provision, so we didn't have mediators at that time. So they wanted mediators to be there. So Supreme Court again took the lead, and some mediators, I still remember, were called from America, who had trained our judges in the district court in 𝐒𝐔𝐁𝐄. 𝐒𝐔𝐁𝐄 was treated as a pilot project. And in 2005 or 6, when this mediation center was established in 𝐒𝐔𝐁𝐄, and Chief Justice of India was coming to the district court to inaugurate that, lawyers ransacked that room. So that was in 2006, the scenario where lawyers did not want. But to, cut it short, and I would like to bring, to come to the point. But in this 17, 18 years, where we have gone, my idea was to emphasize that today, in this 16, 17 years, mediation has taken great leaps in India. It has become, and all lawyers now today accept it with full warmth. Yes, this is one of the methods of dispute resolution, which has to be utilized, which is very good. They have realized that mediation, it is another dimension of their practice, which is adding to their practice, and it is not alarming drop in revenue. Rather, it is the addition of revenue to their the kitty, which they, and their work in the court is not going to be less. So therefore, the mediation has taken off, but then what I want to say here is this, that this as far as the disputes are concerned, it is no more an alternate dispute resolution. Initially, Section 89 was introduced in the CPC primarily for the purpose that we in our courts, dockets are overflowing. We have so much of work, and therefore courts are today crumbling with that pressure, and mediation or arbitration as alternative dispute resolution will take away some work from the courts, and the court's burden will be reduced. They will be able to concentrate on those types of cases which are more important, because every case is not meant for this thing mediation. If today somebody challenges the, say, varis of some provision in the Income Tax Act, it can't be mediated. It has to be decided by the court. So that is one example I am giving. But so therefore, it may reduce the areas. It has done wonders in Western countries, particularly in America, where today 94 to 95% cases are settled through mediation. And even if the case goes to the court annexed mediation, or they have gone far ahead, where it is before the court also pre-litigation mediation, unlike Section 89, which is court annexed mediation, but pre-litigation, there are like very trained mediators. They have their offices. As there's some dispute arises and we have to go to arbitration, they'll say, okay, let us appoint Justice Sikri as arbitrator. Likewise, they say, okay, let us appoint Iram Mazid as mediator in this case. So she is a good mediator. We won't go to court at all. So that kind of environment is there. And with 94, 95% cases settled in America through mediation, and only 5% are going for trial, you can understand that the court practice is 5% and mediation practice is 95% today. So that is the scenario which we want to bring here. But that is one thing. Second most important thing is, of course, it is going to offload the work of the court if it becomes successful the way it has become in Western countries here. But most important, what I feel is that mediation is the best form of access to justice, because it is a win-win situation, which is, between the parties, where the parties negotiate, the parties, of course, with the help of their lawyers and the mediators playing a pivotal role. But then the parties try to arrive at a consensus where they can, and once the settlement is arrived at, as I said, win-win situation, there is no appeal, there is no challenge, nothing, and both the parties are happy with that outcome, which is not in litigation, whether it is arbitration or the court, because there it is adversarial system, and in adversarial system there are only two alternatives: one party will win, one party will lose. But the mediation gives us 10, 12, 15, 20 possibilities in which the matter can be settled. And this, students here would realize that when they learn the mediation and mediation techniques, etc., and learn the success stories, they hear about those success stories, they will come to know that mediation is one such thing where the outcomes are far better than what it is in litigation. So this is more important, and that is why today mediation is spreading, and mediation is here. Future of it, the mediation whose time has come in India also. But at the same time, as I said about the arbitration and how it is becoming cross-border ramification, complex arbitration cases today, the total complexion has changed. That is because of the disputes. The disputes are of that nature. So once the disputes are there, and if disputes are to be settled, now naturally, so mediation at international level also is taking place. One thing which many may not observe also, I have written an article on that mediation today has become, in a way, I said up to now, what the court, if it takes the load of the court, America was also in 70s or 80s, if you know, and you see in America, they were also, the courts were stressed because of these areas. And today that position is not there. So what has happened? by taking load of the court, unnecessary load which was there on the court. Mediation has, and that is my hypothesis, mediation has become a savior of the court system or the legal system. Same thing is happening insofar as arbitration is concerned. Today, because of these investments, etc., there are many bilateral investment treaties or multilateral investment treaties which are signed by the sovereign governments, and the disputes arise under that. The time is not permits me to say much in detail about this, because there can be full discussion on this BIT's arbitration and BIT's. There's a body called 𝐒𝐔𝐁𝐄 or SISD who do these arbitration. But then what has happened? There are few cases which have come and which have been decided by these 𝐒𝐔𝐁𝐄, etc., which have come under great criticism. Particularly the third world country and Asian countries are not happy. And that is why a few years ago in 2016 or 17, India terminated all these BITs and fresh regime is coming. And this has happened not with India, almost most of the countries, because they are not happy with the outcome. Now in 𝐒𝐔𝐁, in order to save its institution, what they did, they also relied upon mediation. So mediation is introduced in their whole process, that before going for this arbitration and before you first try to mediate, and if mediation fails, then only. And that is why we have the system like what we call MED-𝐅-MED or 𝐅-MED-𝐼, etc. So this again, now that is my second hypothesis, that, and this is not only in BIT matters, this may be in many other matters, because today, as I have personally seen as an international arbitrator, also doing so many arbitrations internationally as well, including BIT arbitration, that the stakes are very, very high. And many times in arbitration, as I said, this is adversarial system, parties are not happy with the outcome. But then against arbitration award, there is no scope for challenge. Because on facts and on law, arbitrator, what arbitral tribunal has done, it's a party autonomy, and what arbitral tribunal has done is final. And therefore, award can be challenged only on very limited grounds, whether the jurisdiction is exceeded by the tribunal, or there was bias or misconduct of the tribunal, etc., or it is against the public policy, as we say. Otherwise, it is final. But then they want another cherry, a bite on the cherry, that there should be a provision for appeal, which is not there. Some now institutions are going to have that also. But therefore, how, as I said earlier, it has become savior of the legal system, and it is now mediation is one remedy which is becoming savior of even the arbitration, because of this MED-𝐅-MED. And today, it is not only the commercial disputes. If I may say so in a 1 or 2 minutes, commercial disputes are there in international, at international scenario, where these are being settled through mediation. And I tell you from my, again, personal experience, the issues in international arbitrations are so complex. The papers which are filed may run into 100,000 pages, 1 lakh, 2 lakhs pages, and it takes years there also to decide this dispute. The amount of money which is spent is much more than in litigation. So arbitration, once which was conceived as a which would not take much time, and which is cost effective and speedy, is no more there. Here again, mediation comes. And therefore, what happens that, as I said, 𝐒𝐔𝐁 also, and almost all other organizations, I'm talking about the arbitration centers international, whether it is LCIA, London Council of International, whether it is ICC Paris, whether it is SIAC, Singapore International Arbitration Center, or in India also, they have introduced the element of arbitration into, mediation into that, because they know it is with mediation, if the parties are able to settle, they will be able to settle. So therefore, it is not only, as I said, commercial matters. I give you simple example of Hague Convention on child abduction. I don't know whether many of you know it or not. This is parental objection. After now, internationally because of this globalization, and today there are more than 30 million Indians who are living abroad. So in many cases you may have found that the couple is in America, but then they are not able to get along together, or wife is maltreated, she comes back, and then the disputes arise. The family disputes, matrimonial disputes may be there, and the dispute may be about the custody of the children. So on custody of children, this was the Hague Convention, which was signed by the parties. India is still not a signatory, but then all these kinds of disputes are more apt for mediation, whether it is family dispute or it is this dispute. And so therefore, this today, this arbitration, sorry, mediation has gone internationally, and it is taking, it is giving given due recognition. As Iram has said, this mediation is no more an alternate. It is becoming the main mode of settling the disputes. Only if it fails, the people will go to court, or people will go for arbitration, etc. So in this whole process, what is required? And then I come to this, that look, the outlook of the advocate is not to be same as when he appears or she appears in the court and argues the case as adversarial. When you appear before the mediator, then your attitude has to be totally different. So mediation advocacy is again a totally different. There are many articles on what mediation advocacy should be. I have also written one article on that as well. So what is mediation advocacy and what you need there? Then I say that whole mediation process, and now I'm talking about the mediator. Mediator is not a judge. He is a facilitator and how. So therefore, mediators training is also totally different, and the art which mediator has to learn, she has to learn, is totally different. Apart from that, you have to be very passionate about this cause, and you have to have patience also. You have to have empathy as well. There are so many qualities which the mediators need to have in order to understand the emotions of the parties, etc. So those are very, so therefore it's a totally different field altogether, which you have to learn. Ultimately, whenever disputes arise, and I end with that, whenever disputes arise, then what happens? Parties would like to settle between themselves. Even in the family, there is a dispute, will settle. Between two brothers will like to talk. We may involve our father or our uncle, will like to decide. And when we talk with each other, this is what we call negotiation. So we are negotiating with ourselves. So the best mode of settlement of dispute in a society from psychological point of view also is that the parties are deciding to settle between themselves. But sometimes in negotiations, one party may be weak, one party may be stronger. So therefore, we need the help of a mediator who is trained in these and who will be in a better position to bring the parties together. There are wonderful stories about mediation, and if you hear that, I can come to Lord's College and give a lecture on that and give about those stories. So therefore, I congratulate all those lawyers or budding lawyers, in the sense future lawyers who are today participating in this, going to participate in this competition. As I have seen the program, you will be told about mediation advocacy. You will be told about the qualities of mediator. There are various speakers who are coming up for this purpose. And I again end with this, that mediation is whose time has come. And in future, in due course of time, it is the mediation which will be the main fulcrum of in practice as far as dispute resolution is concerned. Thank you very much.
Thank you so much, sir. Now we will invite you to our college, sir.
Sure.
Yes.
Thank you so much, Your Lordship, for your valuable insight on the international perspective of mediation and how in today's era, mediation has been a popular dispute resolution method for the people to opt. Now, I would like to call Ishani for giving a brief introduction about Miss Kathleen Ruan Lady, ma'am. Ma'am would be dealing with the topic of role of client and counsel.
Miss Kathleen Ruan Lady is a renowned mediator, trainer, consultant, author, and advocate with over 14 years of experience. Specializing in high conflict mediations, she has served as the courts and training coordinator at Family Services of Central Massachusetts, overseeing 5 area courts and training mediators. She is also an educator, having volunteered at Harvard and coached students at MIT in negotiation and conflict management. She has lectured at various colleges and contributed to the Divorce Project and other initiatives. A sought after expert, she has completed facilitator and restorative justice training and spoken on various platforms, including radio and webinars. Kathleen is the author of a chapter in Worry Free Divorce, leading divorce professionals speak, and has expanded her practice globally, including advocating for clients like an Army soldier's medical discharge ratings. Ma'am, we welcome you to Lloyd.
It's an absolute pleasure to be here. Thank you very much for your kind invitation. And it was lovely to hear our opening speaker, sir. It was very, very interesting. I appreciate following you. And what I'd like to do now is go into a slide deck. I'm going to share my screen. And I also want to go ahead and put this slide deck into the chat. So everyone, you can have it. You can utilize it the way that you want to. I'm going to copy the link right now. I'm going to put it into the chat, and feel free to use it the way that is best suited for everyone. Let me find my chat bar here. Let me get out of this share. I'll find my chat bar and put it into the share right into the chat right now. Where is the chat? Here we go. Everyone in the meeting, yes, here we go. Actually, I'm demonstrating a skill that you use as mediators or negotiators, where what you're doing, you talk out loud, especially things like math. It's one of the skills for negotiators to learn. We speak out loud for understanding. It's a tool that can be used as well. So let's spend our half hour together going into this slide deck, and let's go back to the beginning. Here we are, and slideshow. So welcome to all. It's a pleasure to be here. And we are going to talk about the role of the negotiator client in this unknown journey of a mediation tournament where, yes, you have your role play. Yes, you have your client information. Yes, you have your negotiator information. And yes, you're going to be part of a process, but the conversation that you're going to have with the other team across the table from you, you have no idea what they're going to say. So as negotiators and clients, you have to be comfortable with the unknown. You have to be willing to listen and preserve the meaning from the other team, as well as making your meaning known on the table, which requires movement. Because in mediation, like the tournament that I judged today in Texas, they were trying to convince each other and pressure each other to come to an agreement. That's not what the mediation table is all about. Even as a negotiator at the mediation table, we're not pressuring people. So in this unknown journey, it's very important to pay attention to what's being said, to prove to the other side that you heard them. Whether your mediator summarizes or not, you as the negotiator and the client, you need to learn to summarize, to narrate back what you're hearing. Because you read your role play and you know this is what you're trying to do with your strategy. You're coming into this negotiation table with historical meaning of what you're trying to accomplish. But at the table with this organic conversation, you can literally create new meaning, and you can't get stuck in the fact that things have changed because you've had an organic conversation. You have to flow with the negotiation table. You have to move with the table. So when we look at these stages that we have, this is what's going to be happening tomorrow, or excuse me, when the tournament starts. You have these stages of where you're going to be hearing the story, you're going to be telling your story, and you want to be smart about each stage that you're in. When you do your welcome and you introduce yourself and your title, being smart about that is naming your authority. Do you have full authority to settle today? Which is common to hear in a tournament. But the real question becomes, without contacting anyone else, that's what you want to ask the other side. Do you have full authority without contacting anyone else? Don't leave that to the mediator to figure that out. Today, the mediator didn't do it in Texas. So we got to a point in the negotiation where people said, oh, I don't have full authority. I'm going to have to talk to somebody about that. Uh-oh. Now we have lack of clarity on the negotiation table, at the mediation table. As negotiators and counsel of your client, you want to make sure the other side's counsel has full authority, or their client has full authority without contacting anyone else. So you immediately, as negotiator and client, you are immediately starting to think about what you're hearing the other side say. So in these stages of the mediation process where you are journeying together as client and advocate, each one of these stages, when you look at your strategy for your role play, you want to make sure that you're being expressive. You, the client, are telling the story. And if your role play says that you're upset, please be upset, because as judges, we're expecting you to be upset. So please show the emotional tenor at the table that matches your role play. As the counsel with your client, the client's advocate, your job is to represent and advise your client, yes, but you're also there to protect your client. So in stage 2, or stage 1, as you introduce yourself, say that I am here to protect the interest of my client, as well as being here in an advisory capacity. You've got a twofold job as the advocate at the table. You're just not there in the advisory capacity, which we hear all the time as judges. No, you're not. There's something else that you're here to do as well. So name it at the table. And when you get into talking about any business at hand that the mediator might ask you, make sure that everything's in place for your client. My client has had a very distraught journey in this situation and would like to make sure that decorum and we are composed at this mediation table. That's very important to my client. If your role play says your client's upset, you don't want your client to be upset anymore. So you start to name what you need at the table right away. And as we journey through all of this, each stage in your opening statement, look at your role play. What are the facts of your role play? What are you talking about in your opening statement? And as counsel, yes, you're here for your client to be fully understood, to be fully heard. So name it. My interests for my client are what I just said. So look at your role play. What exactly do you want to make sure that there is room for at this mediation table for your client? Don't just leave it up to your client to say what they want. You also are standing guard next to your client to make sure that they get what they want. So name it as well. I'm looking forward to this mediation table being a place of fully empowerment for my client, full agency, full autonomy for your client. This is not your case for court. This is not the competition zone. This is about people being fully empowered. This is about transparency. This is about open-ended questions. So in your opening statements as counsel and client, say so. Say what you're looking for at the table. So these are the different stages that we're moving through in the mediation. So let's move on. Because of your role play and your jobs as client counsel, you are holding the space for each other. The mediator, yes, is doing their job. Yes, they're upholding the principles of mediation. Yes, they're conducting a process. But guess what? Your mediator might not be doing such a good job at that. You do not want it to impact your client counsel role because your mediator might not be doing a good job with the conducting a process. So you interject if you need to with summary and clarity and accuracy, when all of that. But your initial roles is for you as the client. Please tell your accurate, genuine story. that should be about the facts of your role play, but it also should be about your emotional tenor, which I call the meta, because justice and injustice has a feeling. And you have brought forward this story about your life that has a feeling of injustice with it. So please look into your role play and extend yourself. Pretend that is your life as client. And look for the injustice feelings that you can describe at the table. If the situation has been lengthy and frustrating, then in addition to what you're looking for, describe the emotional tenor. The situation has been lengthy and frustrating, and I'm about at the end of my rope. We've come to the mediation table looking for relief from this long journey of frustration. Find your words to describe your emotional tenor as the client. And your client-advocate relationship means you two should be turning to each other as client advocate and talking to each other the rule of 5. If you're not talking to each other 5 times during the mediation competition that you're in for the moment, as judges, we cannot judge you very well on your relationship with each other. So please turn to each other and say, I'd like my advocate to speak now. I'd like my client to speak more about that. Turn to your client and say, are you okay with what you're hearing at the mediation table right now? Turn to your lawyer and say, so can you please explain to me what they just said? When the other lawyer talks across the table from you, turn to your advocate and ask, what's happening right now? So build that in to your role play. Find the places where you can pragmatically build in, we're going to talk to each other. Go for 5 communications between each of you. And there you are, advocate, protecting the interests and the rights of your client. And you're saying that out loud several times as the advocate. Well, thank you very much for what we just heard right now. I'm wondering how this is protecting the interests and rights of my client. I hear you saying this, and so I see that's partially protecting the interests and rights of my client, but I'm seeing a gap. Talk out loud to the table. I'm seeing a gap here in what my client is looking for. So you see, you have to know your story very well to be able to talk that way. You've got to pretend it's your real life. And you've got to listen carefully for the gaps. Counsel, you're listening for gaps, but you're thanking the other side for what they're saying, but you're listening for the gaps. And when you hear a gap, see, because you're not emotionally involved, so you can be pragmatically listening for the gaps. When you hear a gap, you turn to your client and say, I've noticed this lack of information here. This is a gap. This isn't giving you everything what you're looking for. You don't have to go into a caucus to do that. As judges, we understand what you're doing, and we like what you're doing. So turn to each other and talk to each other. Be careful. Don't do what Texas did today. Don't compete. The mediation table is not about competition. The mediation table is about cooperation, because we're all holding the space, not just for ourselves, but for the people across from us. Mediation is a form of loving kindness. We're not trying to negotiate at first. We're trying to understand at first what's happening. That makes the table a place of narration. Thank you very much. This is what I heard you say, but it also makes the table have a fully involved conversation. So we go back to the 3 appeals with Aristotle. If you are trying to talk to someone as client or counsel to the other side, and you're trying to be logical with them, the logos of what you're trying to say, and it's not working, you can't get anywhere with it, then you pivot into a different area. Go to the pathos. Appeal to the emotionality that's happening at the table. In words, something like this: look, this has been a very difficult conversation. This has been a very difficult experience. We're looking for a little empathy here. We're looking for some understanding here. Yes, we made mistakes. Or client counsel, you may start out your strategy with an apology, moving into the pathos of the 3 appeals with an apology. We'd like to come to this mediation table and first offer an apology, Because remember, justice and injustice has a feeling at the mediation table. See, in court, we fight for it. At the mediation table, we name it. So maybe you want to start out your strategy with apology to lower the angst at the mediation table, to make the justice quotient of pathos work for you immediately right away. We'd like to offer an apology for this, this, and this. And how is it? Don't just offer the apology and then talk about something else. Take that apology all the way around full circle. How is it for you to hear our apology? Ask that question as counsel. Ask that question as client. How is it for you both to hear this apology? And for us to start off this mediation process with our apology. Is that helpful at all? Get that clarity from them. If that doesn't work, your other appeal is to appeal to their ethos, which is their sense of credibility, best practices. So you see, because you're having an organic conversation that you can't control, as negotiators, you want to get somewhere. I have a rule of 3. If I hear someone say the same thing 3 times, I know we're running in circles with each other. And I name it at the table as a negotiator or as the mediator that's running a negotiation process. And you as negotiators can say the same thing. Remember, you're the advocate. You're going to jump in there for your client who just said the same thing 3 times in a row because they're emotionally involved with how the justice is feeling at the table. You're going to say, excuse me, as the advocate here, as Ishani's advocate, I have now heard this 3 times. And let's go ahead and step back. It seems like what we're talking about isn't working. So move to the pathos, move to the ethos, and get off the logic of the conversation is what you want to think about doing. The opening statement, you want it to be specific. You want it to be measurable. Who are you? What is your role? What are you hoping to get? You want it to be attainable, what you're looking for at the table, and relevant and timely. What you don't want to do is try to force the agenda as negotiators and clients when you're giving your opening statement. Be smart. Just name the scenario of why you're at the table. Support each other. Pass it off to each other. Now I like my counsel to say a few words, and I like my client to say a few words, but stay within the stage of the opening statement. So many of you try to force the agenda when you're giving your opening statement. Just take your time. There's time for the agenda after the opening statement. As you move forward, your agenda now becomes your steering wheel. You want your agenda. So after the other side gives their opening statement, and maybe they drop an agenda as part of their opening statement, let's pretend they do, you simply say gratitude tool. As negotiators, you have lots of tools. One of them is showing gratitude. Please utilize it. I say it all the time. Thank you for the agenda that we've heard. Name it at the table as client or counsel. And we also would like to add this to the agenda as well. One little segue right here. If you're the mediator, please make everyone write down the agenda. I know I'm not your mediator speaker this evening, but please make everybody work. Don't be the mediator that does all the work and puts the agenda into the chat. You don't need to do that. Everyone can put their agenda. As the mediator, you can ask them to put their agenda into the chat. You don't need to do all the work. You are busy running a process. Let people work at your table. As negotiator and client, don't rush too much into the agenda. There's no rush. We're judging you on what you're doing. I took away points today because the team forced the agenda too soon. I took away a point for that. So be smart about the stage that you're in. And when you do develop your agenda, remember you've got the agenda, but then you've got the speaking order of the agenda. Don't do them together as negotiator client. Do the agenda first, Neutral words, we're looking for monies, we're looking for relief, we're looking for our reputation to be restored. These are agenda items. 1 to 3 words are agenda items. You're responsible for laying out a clear and concise agenda. 1 to 3 words. Monies, renegotiation of a loan, public reputation, restoring public reputation, future forward relationship, restoring a relationship. These are agenda items. Notice they're not whole sentences. Restoration of relationship, 3 words, 4 words, that's it. This is how you lay out a clear and concise agenda. And in the tournament, if the other team's agenda matches yours as well, name it at the table. Seems like our agenda has commonality. Can we combine these 2 agenda items? That comes from you, counsel, or that comes from you, client. Either one of you can name that. So now you're taking the agenda from the 2 teams and you're helping the other team combine their agenda with your agenda. If the mediator doesn't do that, you need to do that. Because you are the negotiator, you are the advocate that's helping your client start off with a very good steering wheel, is what I call the agenda. It's very difficult to move forward in the tournament if you don't have a concise agenda. Now, what you talk about first, please do us judges a favor and don't fight for the first thing. Say to the other team, okay, you'd like to talk about this first, then we would like to discuss this second. So in your role play, because mediation isn't about forcing someone to do something, in your role play, pick out your first agenda item, but also pick out your second agenda item and be willing to bow to the other side and concede for them to discuss their agenda item first. When that happens, when I'm a judge, I give that team that conceded an extra point for their cooperation at the mediation table, which is the culture of mediation. It's cooperation, not competition. You're not negotiating yet, so you don't have to be worried about being a hardliner. You do not want to be hardcore, driving a hard bargain yet. That comes later with negotiation, which we'll look at in a few minutes. So be smart, be specific, measurable, attainable, relevant, and time-based about your agenda. That is why an apology and non-monetary items can go on your agenda, because they're specific to the situation, because something wrong has happened and you need to make amends. So as a negotiator, client, counsel, team, what's an apology? There's 3 parts to an apology. Number 1, sorrow, remorse. If your role play needs this, please understand what you're doing when you offer an apology. We'd like to express our remorse. That's one part of an apology. A second part of an apology, apology is a negotiation. A second part of an apology is accepting responsibility for what happened. So look into your role play. Is there something that you need to accept responsibility for? The third part of an apology is making amends. The settlement agreement is a form of apology because it makes amends. So take these 3 parts of the apology and utilize them to your best interest. Negotiation strategy, client advocate strategy, when you go into a private session, which is called a caucus, please make sure you utilize it well. A caucus is to go deeper, to bring out your confidential information. Caucus is a good place for that with the mediator. A caucus is going deeper. A caucus is also to vent because you're frustrated and you like to air your frustrations in private with the mediator. And you may ask the mediator to do something for you because of your frustrations. We're looking for you to use the caucus effectively, not just pull a caucus because the tournament requires it. So in your strategy, again, of what you're doing, what are you going to do with the caucus? We know what the mediator is supposed to do with it. And as the client advocate, you're advancing your position. And please don't ask the mediator to speak for you. Please find yourself empowered from your own caucus and speak for yourself. Try to consider that option as well, not just asking the mediator to speak for you. So when we look at the caucus, you've got this extra privacy. You can ask the mediator. Use of the mediator is a category where judges have to judge you on. You can ask the mediator for clarity in the caucus. What did you hear them say about this agenda item? We're not clear about this. How come they keep pushing back when we talk about this? What are your thoughts as the mediator? What are you seeing as the mediator? Because you're in a protected environment of extra confidentiality and you can speak frankly. When you transition out of the caucus and you come back to the joint session, you want to thank the mediator for their caucus time. You want to thank the other team for waiting for you while you've been in a caucus with the mediator. See, this is the beauty of the mediation table. All of this politeness and gratitude with the emotional tenor, keeping it at a high level, because being with you, being across the table from you is going to have a feeling for the other team. You don't want to tip people over so they want to become competitive with you in the middle of the tournament, which happened today. I was wagging my finger at these two teams today because they went right into competitive mode. You can get triggered during the tournament, during your mediation, where you're really, truly upset. You don't want that to happen. You want to be poised and professional, so you make sure that you thank teams and you show your gratitude tool, and you've either asked your mediator to transmit information from you from the caucus, or you're going to be saying, we would like to transmit the information now from the caucus session to share with you at the joint session. Name the professional words of what you're doing. So as a negotiating team, the first thing you're doing is getting your clarity about their story. You cannot negotiate well without full clarity of what you understand them that they want, what you understand that they need, the accuracy versus your negotiation now, which is how you want to do it and what you want to do to get what you want, but to show discretion as well. So please don't go straight into negotiation. Your agenda will take you there to negotiation, but please, as you move through each agenda item, please make sure you have your clarity from the other side first before you decide to put an offer on the table. See, when you put an offer on the table, now you've started to negotiate. So today in Texas, they put offers up too soon. Don't put your offer up too soon. Make sure you have all the clarity and you understand all the accuracy. You can ask the other team, please summarize what you hear us saying to you. You can say to the other team, let us summarize what we hear you saying to us. That's a cross summary. You can do that to get your clarity. After they say yes, they've accepted responsibility. Yes, you understand what we're saying. That means that they've accepted responsibility. Once the other team accepts responsibility, now you can negotiate. Do you think that we understand you clearly? Do you think that we understand all these agenda items of what you're saying clearly? Yes? As soon as they say yes, you've got them. Okay, thank you for that. Now let's move into negotiation. Name when you're crossing over into negotiation, or if you feel like the other team wants you to negotiate too soon, simply say, we're still looking for our clarity and accuracy. We're not ready to enter into negotiation yet. This is how you hold back a team that's being too pushy with you. Remember, clarity first and negotiation comes second. So this is what you're doing when you finally get to the negotiation. You've got your clarity on the upper left. You've got everything's understood. Everything's accurate. You've got an apology maybe, and you're thankful for that, all this stuff. And now you're going to go, which is your exploration. Now you get to go in for what you want. You might want to ask some disturbing questions first as part of the negotiation process. How would it be for you if we were able to have all of this? How would it be for you if that happened? The disruption of asking those questions from the other side is to help you understand how ripe, how ready are they for negotiation. On a scale of 1 to 10 with agenda item number 1, are you feeling that this is something that you can provide for us? On a scale of 1 to 10, scale it out. If they tell you, nah, we're at a 2 with that, you know they're not ripe for negotiation. So you go through the agenda items and you ask some disturbing questions on purpose to find out what their emotional tenor is for negotiation. And when you make an offer to the other side, it's supposed to be, at the mediation table, it's supposed to be a win-win. So again, you're running the SMART test with the offer they make to you. How is it specific to your needs? How is it measurable for you? How is it attainable for you? And if when you negotiate, you're looking for the gaps. If you see a gap, well, we don't see this as very attainable for us. You use these words from your SMART testing and you look for the gap in the offer from the other side. But you also make offers that cover the gaps. This is how you use your negotiation techniques. So on the right side here are your negotiation techniques. Today, the teams in Texas said, oh, we want to offer a package. Well, thank you. Your response. So what are you going to say if they want to offer you a package deal with this negotiation today? You're going to be asking in your organic conversation, so please explain one step at a time. Instead of hearing the whole package very quickly, bam, 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 slow them down. Maybe you're going to leverage, maybe you want to have a mediator, put a mediator's figure on the table, potentially. Maybe you're going to be asking the mediator in a private caucus, do you think that this has a sense of fairness to it? Maybe you want to know what your mediator thinks, and maybe they'll tell you, maybe they won't, but maybe you still want to know. Walking away from the mediation process is a form of negotiation tactics. Positional questions. What do you think is reasonable here for us? You heard our story. What do you think is reasonable for us to ask you? So these are all, what does a win-win look like to you? If we concede agenda item number 1, are you willing to give us everything we are looking for with agenda item number 2? These are negotiation skills. You could do these in joint session, or you can do this in caucus with the mediator as well. Reality checking the other team's offer is important. Well, with this offer that you've given us, our best case scenario looks like this. Our worst case scenario looks like this. What's most likely to happen to us is this. And that would be unfortunate for us, or that would be successful for us. So thank you for that offer, because that taps into our best case scenario. What's your best alternative if the mediation table fails today? That's usually how the BATMA gets used, but you can also use it to check, to reality check the offer. It seems like this offer doesn't address any of our needs. It looks like maybe we need to walk away from this mediation. You can say these things if you're getting offers that are just no good. So please think about building this into your strategy when you are accepting offers and when you're translating offers. Lastly, part of getting to a good negotiation as client and advocate is memorializing them along the way. If your mediator doesn't do it, you do it. And I say to people, and you can say to people, we're going to have a living rough draft here. We're going to be writing down some pre-agreements, some partial agreements. Partial agreements are important to memorialize. And you interrupt the other side and you say to them, oh, excuse me, did I just hear a partial agreement here just now? You stop the mediation. Excuse me one moment, please. Did I just hear a partial agreement? Oh, thank you for that. And you write it down on your living rough draft. That's a negotiation tool to keep the partial agreements along the way. Then you can refer back to them when you hear an offer. The reason why this is happening is because Sometimes you don't have to negotiate an offer. Through clarity and accuracy of information, you get a partial agreement. So capture the partial agreement when you have it, when it's mentioned on the table. Just go ahead and capture it right there and then. You can do the wordsmithing later, and you can say, we will work out the actual agreement later. Thank you very much. Let's move on to our second agenda item. So this is my half hour of sharing these thoughts on being a good client advocate. I don't know if we have time for any questions, but my slide deck is for you to look over as well. And please feel free to utilize it any way that you'd like to. Do we want to have a question, answer, or comment session, or are we moving forward with our program?
Dear all, if you have any questions you want to put up for ma'am, you can just raise your hand. We'll unmute you and you can ask your question.
Absolutely. Especially if you had a bad experience in another tournament and you want to know what to do as client counsel, go ahead and ask, please.
You can raise your hand or you can write in the chat box also.
Or talk out loud as well. Use your vocal skills. Remember, negotiation, mediation, we have words. They're either written or spoken. So let's speak out. Let's use our negotiator skills right now. Please ask the question. All right, I'm looking into the chat. Could you please tell us how to deal with a situation where a party has no leverage for the mediation? Let's come out loud about that. What do you mean by no leverage?
Hello, ma'am.
Mm-hmm.
So what I mean by that question is basically to ask you, there may be situations where if you look at the paper from an advocate standpoint of view, litigation would serve you a better purpose than actually going into mediation. In situations such as that, right? As a mediator or even as a counsel for the opposition team, how would you deal with that situation where a party proves no cooperation to the mediation situation and who is ready to fight in litigations, but whereas the other party has no resources to fight the litigation?
That's a great question. That's part of the reality checking and the disruption of asking the hard questions or making the hard statements. You can simply disrupt that if you think that there's no leverage at the mediation table. You can simply say, and please write down these 4 words. These are very powerful words, everyone. Seems like, sounds like, looks like, feels like. Seems, sounds, looks, feels. Seems like this mediation table isn't working for us, and we would have a better experience going to court. That would be a statement you would make if things are not going your way. We have come to this mediation table for open-ended negotiation, generating options, but it seems like that's not happening. Is this what's going to continue to happen at this mediation table? That's disruption. See why it's powerful? Oh, and the other side says, oh, we're so sorry, we didn't mean for that to happen. No, we want you to say. So this is how you say that. If the other side you don't think has any leverage, remember, this is not your case for court. You're not judging the leverage of the other side. You're trying to meet the needs of the other side. So make sure as a counsel, you keep your case for court off the mediation table. You can use it as a bargaining tool, a negotiating tool, if you think your client isn't making any headway. But be careful to keep your case for court off the mediation table. Next question.
Hello, ma'am.
Hi.
So my question was regarding the issue where, the mediators, they try to interject too much into the competition, taking most of the time. Like it has happened at times where they're doing too much, they're interjecting too much into the competition. Like how do we then, move forward with issues like this? How do we like take the time from mediator to actually make the competition more efficient?
Yeah, it was mentioned to me the last training I did. I think think it was Pakistan. Well, first of all, how long do you have to mediate your case? Do you have 60 minutes? Is that what your time is for this tournament? Is that correct?
Yes, ma'am, I think so. It's about that
Okay.
much.
Okay. Remember that you're being judged on what you do. You're not being judged on impatiently trying to get somewhere in the future. So you want to be patient with your mediator when they summarize. So please don't tell your mediator to stop summarizing. That's happened in tournaments. That's a little off-putting, because guess what? That mediator is trying to win awards as well. So please don't do that to your mediator. But what you can say is thank you for that and move on. If your mediator repeats themselves with their summary, then you can say, thank you very much for that. But you've already said that once. You've already stated that. That would be the strongest correction that I would suggest that you make with your mediator, because they are trying to compete as well. And remember, the summary is clarity and accuracy, and you just say thank you, and then you keep moving. You just keep moving. If you are impatient that your mediator's interrupting, it means that you are afraid that you're not going to be able to compete well. And that's really not true, because as judges, we're not looking to see that you get to a resolution. We're looking to see right in front of us, whatever's happening is happening well. And being patient with the clarity of your summary of your mediator is part of the process, because your mediator is protecting the culture of mediation, which is narration back, which is summary back. So be patient with that, would be my advice. Next question.
Okay, so my question mainly pertains to the demarcation of roles and responsibilities when it concerns like client as well as counsel. So is there exactly what a client should say or exactly what a counsel should say, or is it like a fluid concept?
It's all of it. Yes, yes, and yes. It's fluid between them, but the client should be the one that's telling the story that's bothering them, not the story of, oh, I've been involved with this business for 25 years and I've been a person here in this culture. Not that part of the story so much. That should be one line of history, but they should be talking about what bothers them and what they're trying to get accomplished, what went wrong for them. That is specifically the role of the client. As judges, we want to hear what's bothering you, what's upsetting you. What are you trying to get? What do you want to have happen? What do you want to have to stop happening? The role of the advocate in the beginning is say, hey, I'm here to protect my client's interests, and I will be acting in an advisory capacity as well as protecting their rights. Twofold job, not just advisory capacity. After that, those initial specific roles, then you start to merge together, talking to each other, referring to each other. Because remember, advocate, mediation table is for your client. It is not for your case for court. It's for your client to settle below or above the law. And if you don't see that happening as the advocate, you can simply say, I'm not seeing the flexibility that we were looking forward to from this mediation process. You insisting that you get the culture of the mediation process for your client. We're looking here for option generation, not to be bossed around today, not to be pressured into saying yes today. We're looking for option generation. So as client, refer to the culture of the mediation table for your client. Insist that the culture of the table is effective for your client. Next question, please.
Yes, ma'am. Ma'am, I have one other question with respect to the mediator setting the agenda. Usually, it is the parties and the councils who set the agenda for the mediation proceedings. But if in case a mediator feels like one agenda which is crucial for the component of mediation the parties have missed it, can the mediator proceed to set that agenda on the table, and can he actually tell the parties to discuss that agenda first?
Yes, and if you're smart as the mediator, you will summarize after client and counsel have finished their opening statement before you go to the other side to hear their opening statements. I summarize. Did I get that correct, everyone? Yes, they've accepted responsibility for their words. So then you go to the other side and they give the opening statement, and then you summarize for them. And now you can segue. See, transition statements are the golden glue at the mediation table. Thank you very much. Here's a transition statement for mediators. Thank you very much for your opening statements. Now, as your mediator, let's start to set the agenda. And as your mediator, this is what I heard that's important for you today. Correct this, and this. Correct, Ria? And is there anything else, Ria, and your counsel that you would like to see on this agenda as well? As hear those transition words as well. And then my client advocate can add what they want on their agenda. Or you can say, as the mediator, I've heard you say you want this, and this on the agenda. Is there anything else that anybody wants on the agenda? So as the mediator, when you hear agenda items being put down forth, you can start that process. Or as the mediator, you can say, I've heard your opening statements and I've heard agenda items. Let's go ahead and now write down those specific agenda items. Everyone, please make a list here. Agenda item number 1 that I heard was this, 2, 3, 4, 5, 6. It's up to you. It's your style. And you have to feel confident in your style. You all have your own style, your confidence, and your courage to dip into something, to dive into something. Great questions so far. Anyone else?
Hello, what I wanted to ask was, so as a negotiating team, if the other party, if the other negotiating team is basically speaking at a length, is it an option for us to like interrupt them, or is there anything else we could do?
Yes, and you're going to interrupt them with the spirit of mediation, where it says, excuse me 1 second, we need to interrupt you. Let us summarize what we've heard you say thus far. Hear that transition sentence? Let us summarize what we heard you say thus far. Go get what you heard them say thus far. Now you're on the table. Now you're talking. Now we can judge you for that. And then you can simply say, please continue. Because if your brain is too full, then guess what? Interrupt them. And if the mediator doesn't do it, you need to do it. Hopefully the mediator will do it. And you won't have to do it for yourselves. But do it for yourself if the mediator's not doing it for you as client advocate team, either the client or the advocate. Great question as well. Next question.
Ma'am, I have one question in my chat box. The question is from Varsha. She asked a question regarding how a mediator should be. In competition, judges generally prefer a mediator who can control the session and be a little stern, but at the same time, other judges prefer a soft and polite approach. Which do you think a better approach to being a mediator is?
A mediator is conducting the process. So the firmness to a mediator is with the structure of the process. So that's where mediators are firm. Where we're soft and gushy and warm and cozy and all those words is when we summarize. See, we build trust, rapport, and bonding when we summarize. So as a mediator, you should be controlling the process by summarizing and saying, thank you for that. Is that correct? Is there anything else? It's a narration back. It's a 3-part narration back when you've heard summary. Is that correct? Is there anything else? Don't forget to ask the anything else question. I don't ask that in the opening joint because my firmness as a mediator, I've asked for brief opening statements. So see that word brief? That's where my firmness comes in because I'm running a process. Every river has its banks. I have to put banks around my stages. So if I've got opening statements that are going on too long, I need to interrupt and say, excuse me 1 moment. Let me just, my brain is too full. Let me just interrupt you right now. I want to make sure I want to summarize what I've heard you say thus far. And not but, and I've asked for a brief opening statement. So I'm going to be asking you to bring it to a conclusion. Hear that firmness right there? But I'm going to summarize. So there's my gentleness when I summarize. There's my agency and autonomy for you. There's my loving kindness for you because I'm summarizing, but I'm also firm as well. So they have to go side by side, but firm with the process, but gentle and caring with your summary. That's where we build our trust, rapport, and bonding with our summary. Let me make sure I hear what this table is saying right now and throw it to the table. As the mediator, you're not there by yourself. You're there with your title as your mediator. Right now, we're in the opening joint state process, so I'm going to be asking you for a brief statement. And right now, the mediation table is filled with lots of conversation. Let me, as your mediator, let me summarize this conversation. So you interrupt. That's your firmness when you interrupt, because they've been talking too long without you. They need you to jump in there and summarize. There's your firmness. Thank you for that question. Next question.
Hi, Kathleen. So I had a question.
Mhm.
So what do we do in situations when, for example, the other team, they're being passive aggressive? Passive aggressive as in they're being too stubborn with their interests, or they are basically not being collaborative. So if we be aggressive to them on our part, then that would affect our relationship building. But if we like be nice to them and be collaborative, then it also places our interests at risk. So how do we
Okay.
handle such a team?
So like today, the teams in Texas were passive aggressive. They were saying things like, well, if you would have let my client finish, that's passive aggressive. When you hear that passive aggressive stuff and that emotional tenor starts to get competitive, apologize. Oh, we profusely apologize. Pardon us. So you have to use your apology when you start to hear the passive aggressive. When someone is too aggressive, this is how you say it. In the spirit of the mediation table, this is how you say it as the other team. So let us interrupt you 1 second. We want to thank you. So you use your gratitude tool always first to push back an aggressive team. We want to thank you for the passion that we're hearing from you. We can tell this matters a lot to you. On a scale of 1 to 10, how important is this topic to you right now? Slow them down. Go get your clarity. Make them responsible for giving you the accuracy and the clarity that you're asking them for. And then for you, you're going to be asking for what you want. You're going to be saying, we need to have some space at the table to speak as well. Are you able to give that to us? Hear that question? That's a great question. So you take responsibility for what you're looking for, because the drama triangle, persecutor, rescuer, victim, when they're being too aggressive, that puts you into the victim role. They're the persecutor because they're too aggressive. It puts you into the victim role. And what breaks the drama triangle always is responsibility. So show their gratitude and say, thank you very much for your passion, but put responsibility on yourselves for asking. Don't play victim. Put your responsibility on yourself for asking what you need. Are you able to give us time to speak as well? Because we need that time too. Go get what you want. Don't sit there and feel beat up by them. That's playing the victim. Don't play the victim. Just interrupt them and thank them for what you can thank them for. Find anything to thank them for, but then put forward what you're looking for as well on the table. Great question. Next question.
As a mediator, if you feel like your co-mediator is not cooperating and they're not doing that part of what they're supposed to be doing, how would you address a situation like that without being disrespectful?
So if you have a co-mediator, it's a dance together. And you have to turn to your co-mediator and say, thank you very much for that. You have to turn to your co-mediator and say, could you please do this now? Again, don't play the victim role. Go get what you want from your co-mediator. And if your co-mediator says something and they left something, you say thank you to your co-mediator. Once again, you say, in addition, hear those transition words, in addition, and then that puts you onto the table and you can speak your mind. In addition, I want to add this. In addition, I heard you say this to the teams when your co-mediator summarizing and they leave something out. In addition, I heard this as well. Hear those transition words? In addition, as well. So put yourself out there, but thank your co-mediator first. That shows the politeness, but the firmness then is when you say what you need to say as well. And my co-mediator has already mentioned confidentiality. My co-mediator has already mentioned volunteer. So I'm going to be talking about this. Give them credit where credit's due, but name it and then move on with what you need to do to be judged as a proper co-mediator. It's always the gratitude tool. It's always a relationship. It's always a dance. Next question, please.
So I had a question as a mediator. If the co-mediator is continuously, like, say for example, I would like to bring up a point, or I would like to bring in a caucus or some point like that, and my co-mediator has decided to bring something else instead, or they've decided to go in a different direction instead of that, where I feel it would be better to do something else here. How do we address that without undermining them or being disrespectful?
We summarize it. We look at the co-mediator and we say, so my co-mediator is heading in this particular direction, and thank you for that. And I would like to also bring out on the table this direction as well. What would everyone like to do? Shall we do one first and then one second? What would you like to do? Or you can turn to your co-mediator and say, so thank you for what you've just offered. I am thinking this as well. But you're eventually going to have to turn to the teams and ask them which way do they want to go. Or you might say to your co-mediator, might this be a good time for a caucus? Hear that question? Might. Hear that transition word? Might. That way you're not saying something and your co-mediator is saying no. You don't want to put yourself in the position. So you use the word might. You make a suggestion to your co-mediator. As judges, we know what you're doing. And if your co-mediator shuts you down, I'm going to give you an extra point for being so polite with your co-mediator relationship. And I'm going to take away an extra point from them for saying no to you in front of the table, right? So remember, it's respect. The mediation table is a culture of respect. So maintain that respectful attitude. Next question. You can follow that up if you want to ask another question.
This was somewhat of a completely different question, but I wanted to ask if the parties, let's say I've set an agenda, they're starting on something else, and they're just going in circles. I feel like they're making a little progress, but not much. It's just kind of wasting time here. But also, I wanted to ask, at what point should I really interject? Because they're making some progress there. So should I be disrupting that progress, or
Yes, you should be, because they've repeated. I have a rule of 3. They've repeated themselves 3 times. It's the 3 times that tips me over as the mediator. I'm going to say, okay, so I'm going to interrupt, please. As your mediator, thank you very much for the progress that I'm seeing. You have said this, 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 and this. That's wonderful. Thank you, because it's keeping this mediation table moving. Thank them for a reason for the culture of the mediation table. Thank you for keeping this mediation table moving. Thank you for finding partial agreements with these 4 areas. And as your mediator, I'm also hearing we have gone around in circles now 3 times with this issue. Let's make sure you're hearing each other, put them to work. What have you heard the other team say? Please tell me. Please summarize what you've heard the other team say. And then go to the other team and say, what have you heard the other team say? And then you interject. As your mediator, I will also like to add this. I have heard this as well. So you're going to clear it up. But first, you're going to congratulate them on what they've accomplished. Even if it's minuscule, the momentum of congratulating, which is another form of gratitude tool, will push them forward, which is what we want with positivity. And if they are understanding each other, you simply say, you guys are understanding each other. Why are we still talking about this for the 3rd time in a row now? What is wrong here? What is off here? You guys are hearing each other clearly. Or you can say, this is where you're not hearing each other clearly. Now that we have that cleared up, can we move forward? Or maybe you're going to pivot off of that conversation. Can we put a pause in this conversation and go to another agenda item? So you have lots of choices as the mediator, depending on what you find out from your parties. Great question. Thank you.
I have a small follow-up here.
Anand, sorry for interrupting, but actually the time has been exceeded and the next speaker in line is running late because she has a packed schedule today. So she's also available. You can ask her question, a follow-up question, because the time is limited and ma'am has to go somewhere else. So thank you
I
so much,
do.
ma'am,
You're
for
welcome.
entertaining all the questions from the participants and giving such a valuable insight on the topic of role of client in counsel. We are very thankful for you to be there in
Very
the
welcome.
workshop.
It's been a pleasure. Have a great rest of the day. Bye-bye, everyone.
Now I would like to call Paris to give a brief introduction about Miss Linda Heng, ma'am, who would be dealing about the topic role of mediator.
Linda Hay is a seasoned mediator and co-founder of ResoluX, Resolution Exchange, a tech startup transforming global dispute resolution and accredited IMI mediator. She serves as principal mediator at the Singapore Mediation Center and is an international mediator with the Mainland Hong Kong Joint Mediation Center. She is also a training faculty member at various mediation centers and a fellow of the Singapore Institute of Arbitrators specializing in mediation, arbitration, and hybrid dispute resolution with a strong foundation in conflict resolution. Her journey began with training at Harvard's program on negotiation in 2005. She is a passionate advocate for peaceful conflict resolution and actively volunteers in the Singapore mediation community. She holds a bachelor's in business administration and master's in mass communications. Ma'am, we welcome you to Loyal.
Hello, can you hear me?
Yes, ma'am, you're audible.
Fantastic. Okay. Thank you so much for having me. And I do apologize that this is going to have to be quite a quick one because I did not expect the time to overrun this way. I do have another appointment to run to, but nonetheless, I think actually Kathleen had shared quite a lot of, gave quite a comprehensive picture of what a competition should look like. And she's also touched a fair bit on how, delicate the dance is and how much time should be used, in a competition setting. So I'm just going to do a very quick overview, and given only 30 minutes, I actually had only prepared a quick zoom in on some of the more, pertinent things that have popped up in some of the mediation competitions that I have observed and judged. And so I just want to give you a little taste of what I personally, as a judge, would be paying attention to in a competition when it comes to the role of mediators. Now, as most of you know, there are many, many different types of mediation competitions around the world, and they vary, depending on the scoring rubrics. They sometimes vary according to whether only the negotiators are being judged or whether the mediator is being judged or everyone is being judged. So it is a very tight space for many people to be judged at the same time, especially if you only have an hour. But the main performance criteria that we see that is, critical for a mediator who is being judged would be some of these, as you will well be aware. Process management and structure, communication, interpersonal skills, whether you're impartial, whether you're professional, whether you are able to move the parties towards resolution in a very realistic manner. Your use of the mediation techniques in things like summarizing, reframing, looking for common interests, and the strategies you have to deal with parties who are difficult, strategies for overcoming impasse. We judge a mediator on how adaptable they are, depending on the temperature in the room. We judge a mediator on how responsive you are to things that you might not have expected in terms of either the content of the dispute or in the way people are behaving. And we also sometimes judge mediators if they collaborate well with their co-mediator, depending on how the competition format is drawn up. I actually want to zoom in only to 3 or 4 parts, which I think is particularly critical for a mediator. Now, the first one would be the most obvious, because this is when the mediator takes the center stage. It might be the only time when the mediator is able to command the room during the competition for such a long period of time without being interrupted. So what do judges want to see in the opening statement? In the opening statement, judges want to see that the mediator is able to create trust, develop rapport, set expectations, and encourage constructive dialogue. Now, we all know that by now, all of you would have a very, very prepared script, and you will have a very good sense of what you want to say and how you want to say it. And this is the part that you have rehearsed to death with your teammates and with your coach as well. So, suffice to say that things like setting a positive and neutral tone, explaining the process clearly, ground rules, sharing perspectives, encouraging them to active listening and empathize with each other, and some amount of optimism about the resolution, all that are the do's. What we don't want to see is you sounding very robotic or scripted. And it does happen a lot, especially in student-run competitions. I do empathize that it is very hard for students who have not actually mediated in a real scenario to understand what it means to sound natural. But this is something that you're going to have to discuss with your coaches. How do you deliver it naturally in a way that is compatible with the dynamics in the room? So be careful not to sound robotic or scripted. You should not be, showing bias in opening statement, and it sometimes shows in terms of your body language in very non-verbal gestures that you might spend maybe 3 more seconds on one side than the other side. And sometimes it's just a habit, but you might want people to mirror that to you if you have a tendency to be more left or right oriented, for example. You don't want to overload with legal jargon. You should not be ignoring non-verbal communication. Now, what do I mean by that? In the opening statement, it is very attractive for you, very tempting for you to just deliver a monologue. But the truth is, you have to be sure that your parties are listening. You have to demonstrate that you're catching their eye. You have to demonstrate situational awareness. If someone is not paying attention, if someone is staring at his notes, if someone is staring at his laptop or phone, you're going to have to draw that person in and make the effort too. So as a judge, I will be watching to see if you are merely delivering a script, but you are actually actively paying attention to the room and developing rapport with your parties. What is most common, a common mistake in student competitions is when the mediator overpromise or guarantee outcomes. And what do I mean by that? Sometimes in your script, and it could be sometimes maybe a bit cultural, I think, but having judged at a number of international mediation competitions, I have to say that most of the judges agree that we do not really enjoy seeing mediators who are overly enthusiastic. So there's a subtle difference between being positive and being overly enthusiastic. So some mediators tend to use words like, with all your positive energy, I am sure that we are going to be able to reach a resolution by the end of today. I'm sorry, but that is a little bit crossing the line, and you want to be very careful, because as a judge, to me, it's a red flag warning. I'm going to have to wonder whether you are in sync with the temperature of the room and whether you are over-promising something that is not within your capacity to deliver. Be very careful with too many perfunctory thank yous and individual acknowledgements for 2 main reasons. One, I agree with Kathleen that showing positive and compliment and showing unconditional positivism and thanking parties is a very important part of demonstrating collaboration. But at the same time, too many can diminish the utility of each thank you. And it may come across as condescending or dismissive, even if you do not deliver it with sincerity, right? So are you just saying it to stop someone in their tracks, or do you really mean it? I think these are the things that judges are paying attention to. The other aspect about having too many individual acknowledgements, and I see that a lot in competitions. Thank you, Mr. A. Thank you, lawyer A. Thank you, Mr. B. Thank you, lawyer B. All that time is really quite unnecessary, especially in a competition where you have very limited time to play with. So for the mediator, I know it is the time for you to take center stage, but really I think you can do a lot more with being brief, being concise, being sincere, managing eye contact, and really being present. Your presence, your charisma, the way you vary your tone, the way you vary your language, the way you look at people in the eye, can do everything that words may not necessarily be able to do. So be careful that you are really connecting with people and not merely delivering a Toastmaster speech. It is not a Toastmaster speech. Moving on to problem solving. What do judges want to see the mediator do? Judges want to hear the mediator emphasize interest. They want to see the mediator move the parties through the different phases in very specific segments. So exploring the issues is one clear segment. If parties go into generating options at the exploration of issue segment, the mediator needs to be quite firm in the leadership ability to halt them and say, no, let's leave some of these options to the later part. Let's hear a little bit more about this issue. What are your thoughts about that? So we want to see then you move on to options generation in a very deliberate manner. We want to see you explore every issue on the agenda before options generation, and we want you to be able to generate extensive options. Now, in the exploration of issues, which is where the problem solving happens, and options generation where problem solving happens, what we prefer not to see is the mediator merely be a note taker and or a referee. Okay, and I say it cautiously because yes, to some extent, the mediator is a bit of a note taker. You do pay attention to what's happening, you take down notes, and you keep the parties on track with where you're going. The mediator is a little bit of a referee. The mediator invites parties to speak. But if that is only all that you do, then I would say that the judges are okay, you didn't do quite anything wrong, but we didn't see anything particularly impressive either. What we do want to see is that the tendency for parties to go and get entangled in issues, the mediator is able to get them to be focused on issue at a time, be focused on option generations, specifically allow for extensive options to be generated before any amount of criticism and evaluation is done. So these are the leadership qualities that we want to see in problem solving. Now, the other aspect about problem solving that mediators should pay attention to is, again, the tendency to be overly optimistic about solutions. There are, of course, certain competitions where parties are very aggressive, but more often than not, I feel that student competitions, parties tend to err on the side of being too enthusiastic about resolutions. And then they can sometimes go into resolutions very quickly, and the mediator is, complicit as well in saying, oh, well done, all of you are so constructive, so we have an agreement here. Now, that is not impressive for a judge. As many of us judges have already told you, we are not looking so much for you to reach a resolution. In reality, you can't reach a resolution in an hour, not in a real mediation, and even in student-led competitions, maybe one or two agreements, but there still be a lot of things that need to be discussed further. What we don't want to see are half-baked agreements that sound good in theory, but actually have not considered the cost, You have not considered the money. You have not considered accountability to your shareholders and to your other stakeholders. So please be very careful when it comes to for the mediators, that if you see parties who are going at breakneck speed towards being really collaborative, really positive, and getting to a resolution quickly, the judges want to see the mediators ask reality testing questions. We do want you to get them into caucus. We do want you to make sure that they understand the implications of agreeing to these resolutions. You have to ask good questions. You also have to go through the process of doing the Bettner and Wettner. Sometimes it is very tempting for student mediators to look at options on the table and say, oh, we've got good options here, it sounds great. And you do reality testing on those options, but you do not actually deliberately bring parties into considering, would they be better off if they go to court? Would they be worse off if they went to court? I know that in a mediation competition, you actually want to steer parties towards an amicable dispute resolution. But in real life, as well as a student mediation competition, it is your duty to make sure that parties do consider whether they'll be better off in court. And it's not taboo to bring parties through what would the Bettner and Wettner look like if they did not resolve at the mediation table and they went to court. So if, again, the principle is, if the Bettner is equal to or better than what are the options on the table, then as a mediator, it is your job to help parties evaluate whether they should not then reach an agreement. Again, not for you to say, okay? It's not the mediator's job to say things like that, but it is definitely the mediator's job to guide the parties through the process. So be very clear that the judges are looking to see if you are working for the good of the parties and not just working for the good of reaching a resolution. Thirdly, communication skills. Judges want to see mediators value add through constructive reframing, building trust. They want to see you be an active cheerleader when appropriate, not excessively, and be a role model if there is co-mediation for warring parties to communicate better. Now, why do I put this picture here as a red flag warning? I think that one of the most common mistakes that student mediators have is that you're very much in your head when you are at the mediation table. You have prepared a lot, you have had a lot of, contradicting, advice from many judges, well-meaning coaches, judges like myself included, and you're in your head wondering, which tactic should I use? Should I follow this judge's tactic or should I follow that coach's tactic? And you're in your head way too much. The best way to communicate, to demonstrate your communication skills in a student competition, is to be very, very present. And I think Kathleen had touched on that too. You need to be in the moment. You have to trust that all your preparation work has been adequate, that your vocabulary is either there or it's not there. You are either articulate or you're not articulate. This is not the time to overthink it anymore. You have to be very present. Because if you are not present, you can't listen actively. You can't speak selectively because you need to read the temperature of the room. You can't summarize concisely and neutrally. You can't reframe the negative emotions into positive ones because you're not even present enough to pick up on it. You must be able to hear very clearly what are positions vis-a-vis interests. I find that when it comes to positions and interests, maybe this is something for the coaches to pay attention to. Students are still not particularly alive to interest versus positions. We often ask students, what do you think the interest is? And students still tell us the monetary amount that is at play. Be very careful that mediator's role is to constantly articulate the parties' interests, remind them that you said earlier that your reputation is important. How does this aid towards you reaching, protecting your reputation? Or you have said that time is important to you. How would this help you to be efficient? How would this help you to account to your stakeholders? So parties will not be inclined to say their interest. It is the mediator's role to say that. And for that to happen, the mediator has to be very present. A mediator needs to focus on common ground and de-escalate the conflict. Now, what we don't want to see mediators do in terms of communicating, and we often talk about summarizing and reframing, is for the mediator to parrot what the party says word for word. It is very tempting for the mediators to do that, especially student mediators, and that is not what we call a summary. That's just called parroting. So be very careful to summarize selectively. Please do, in your summary, be even-handed. Be careful not to show bias. Simplify the language. Don't use judgmental, overloaded language. Don't overcomplicate the summary according to how you think it is, in case you can distort the original meaning. You also want to be very careful to summarize and reframe their emotions. I hear that you were frustrated by something. So don't dismiss or minimize people's emotions. And for all of that to happen, I cannot overemphasize, you need to get out of your head and be very present in the moment. Finally, for caucus. Judges want to see the mediators use caucus strategically. We want to see you be very deliberate in using it to reality test, to break impasse, and to discuss, things that might otherwise be challenging to address in joint session, such as your, BETNA and WETNA. So in the caucus, please explain your purpose clearly and do it early in the caucusing process. Maintain a neutral professional tone. You need to be focused. You need to help parties maintain the momentum, help them to move on. You need to confirm what can be shared before you break for the next private session or for joint session. And you want to manage offers and counters judiciously. Now, what do I mean by that? Again, red flag warning, you are not a postman. You are not a postbox. Even if there are offers being made and there are options on the table that parties request for you to bring across to the other side, do not be, the judges will be looking at the mediator's response to that. The mediator first must make sure that the offer is one that is worthy to bring across. Right? And for it to be worthy, you probably should have a good idea of what the zone of possible agreement is already, your ZOPA. If you are at the first private session and you don't know the ZOPA, it has not been mentioned in the joint session earlier, it is your job to go to the second private session and do all your exploration and get a sense of where their zone of possible agreement is before you go around making offers. Because any offer that is not made judiciously can be construed as an insult offer. And we know that offers can also, anchor the discussion in a way that might not make it constructive. So be very careful that even if parties use you to go and make an offer, you should temper them to tell them that, thank you for giving me the authority to share this offer with the other side, but please allow me to make the decision of when and how to make this offer and whether it's appropriate. After all, we want to make sure that the offer will be well received before we make it, right? So be very careful about managing offers. Don't be premature when it comes to having caucus. Don't call a caucus immediately when parties are emotional and you feel that, I can't handle this, it's really awkward, so I'm going to go into caucus. The judges do not look well on caucuses that are too early because it demonstrates that you do not necessarily know how to manage the joint session. Be careful in managing caucus to be even-handed again. You are in a private and confidential setting, but you do not want to be accused of by a party of saying that you said in private caucus that I had a very good case. So be very careful even in private caucus not to show bias. Do not share confidential information without consent. Do not manipulate or pressure. Now, what do I mean by that? Just because you go through a BETNA and WETNA exercise does not mean that you should use it as a threat, right? Do not be tempted to adopt the tone that just because you are probably going to be worse off going to court, you are telling that person, therefore you have to settle. So make it a very professional, sometimes even clinical and detached discussion when it comes to Bennett and Wetner. Empathize with the parties that this is a challenging and difficult decision to make, and then give them some time to think about it. Now, doing that, when you do that, the judges will feel, okay, you know, mediator, you have done your job and you have not pressured and overly manipulated or put in your own persuasive techniques to get the parties to settle, but rather you are showing respect to the parties and giving them the autonomy to settle. Be careful also not to spend too much time in one session. I think in a competition, there probably is a time limit, so you probably will not run afoul of that. So to end off, I think for mediators, judges are most impressed by student mediators who are present and good listeners. We know when you are scripted, we know when you're in your head and you are just going through the motions or being a referee without really being present and hearing the texture of the conflict and reading the personalities in the room. So if you're present, you're a good listener, it will come across. We are very impressed by student mediators who are authentic and sincere, not using, you know, some of these cliche sentences that students like to use, or even mediators, professional mediators. We do sometimes have very cliche phrases like, I understand, I hear you, but actually in everything else that you do, you are not showing that you're understanding, you're not showing that you're hearing, right? So be very authentic, be sincere. If you don't understand something, ask. Judges will be very impressed because it shows that you're authentic, you are humble, you are really paying attention, and you're showing respect to the parties. We are impressed by students who are matured and balanced. By that, we mean that you are not too naive at picking up on the easiest way to reach a resolution, but you are very circumspect about whether a solution or an option is going to work out in practice. And of course, we are impressed by student mediators who are concise and articulate. I am, again, maybe it's very cultural, and I'm not a fan of being overly verbose. Students who are concise, brief, to the point, are more impressive to me, I feel, because it actually takes a lot more thought to speak briefly and clearly and specifically. So bear in mind more than that you have a limited time. And if a mediator overspeaks, uses too many words, is overly flowery and expressive, you are not necessarily impressing the judges, and more importantly, you are also taking away time from the other competitors from showing off their skills, right? So that's all from me for now. Any questions?
Hi, ma'am.
Yes.
I have a question. So, when a mediator is mediating and other parties are at a deadlock and they're not willing to move forward, how could a mediator deal with this situation? Could we suggest what could we do?
When the parties are at a deadlock, I think it is extremely rare, actually, for any of the cases to be written in such a way that parties cannot find common ground. Most of your mediation case, in real life, parties do get a deadlock, but in a competition setting, very unlikely. Now, if the parties are really at a deadlock because of personality issues, then the mediator's role will be, I think, things like summarizing what has happened so far, reminding them of their interests again, reminding them of their common interests, and then asking them what more they have to say. So helping them to keep the process going. Of course, if that still fails and that is still drawing a stone silence, which does not bode well, honestly, for the other student competitors in the room, it does not bode well for them, then of course a mediator can always call for a caucus.
Okay, ma'am. Thank you. Another question that I had is, it's possible that, at least at this level, that mediators might not understand quite the proposition that the parties are putting out, for example, an option. So is there any good way that we could clarify in case that we don't understand?
If you don't understand, just just clarify, okay? Or I mean, there is no shame in asking for details. So you could say that, in a very humble way, let's take a minute here. I would like to, find out a little bit more about this particular proposal from one of the parties. Can you please, take some time to explain more about what this proposal entails? It's fine.
Okay. Thank
Hello,
you.
hello, ma'am. Ma'am, I have
Yes.
a question with regarding to the confidential information for the purpose of the competition, right? So
Yes.
let's say if there is any proposal on the table which is actually quite contradicting to the which is actually just in the overall mediation, but it is against the confidential information that a party has received, right? How should a mediator go about in reaching a solution where it is just to both the parties then?
What I'm hearing is that you are asking about the substance of the case, having some amount of confidential information that is not well utilized in the joint session. Is that what
Yes,
you're
ma'am.
asking?
Yes,
Yeah.
ma'am. Yes.
Yeah. I'm very sorry, but firstly, the mediator should not even know that there is a difference in the confidential information, because the mediator should not have a privy to the confidential information. So the mediator should not even know that there is a gap in the information. Secondly, the mediator always works with what the parties give to them in the room. If the parties don't give it to you, whether for whatever reason you know or you don't know, you should not be the one to bring it out. You could, if you suspect that there is more that should be said that has not been said, you should definitely bring up your suspicion in the caucus. So caucus is the time when you want to address some of these things that are not convenient to talk about in joint session. Yeah. So in the caucus, then I might be very deliberate to say that, it seems to me that perhaps there are some things that should be considered that have not been discussed, and use that as a bait to open up the conversation. Is there anything else that you are able to share that could shed light on the matter? Yeah, but do that again in caucus.
Yes,
Should I answer your question?
Yes, ma'am. Thank you.
Ma'am, I had a question. Basically, it is generally said that mediators should not lead the parties into saying anything, or they should not be forcing the parties to go in a particular direction or anything like that. But then if, for example, a party is asking some questions, some very relevant questions, and the other party is not responding to any of these questions, or they're just kind of omitting, they're moving around it, and I feel as a mediator that if an answer to these questions were given, it would be very, very beneficial to moving to bring about more options to getting a solution. Is it possible for me to ask them to answer that question, or how would I go about doing that?
So it comes back to how your communication skills. If you speak on behalf of the party asking the questions, as in you parrot the questions that's being asked to the other side, then you are not doing it in a very politically correct manner, because you can come across as being biased, or you can come across as sounding partisan. However, if you summarize what that party has asked. So, for example, what I'm hearing is you have concerns about this and you have questions about that. Am I right? And the party says yes. Then I will bring across to the other side and say, what do you think about that? So there is a subtle difference between being the one asking parties the question versus summarizing one side's question and bringing it across to the other side. So it is about demonstrating their skill. Of course, having said that, if at the end of the day, the parties are still not responding, then you have to remember to park it for caucus. Or you can even point it out. I sense that, there may be some things that we might need to discuss in private. Maybe it's time for us to call for a caucus.
Yes, ma'am, that was very helpful. Thank you.
Thank you. Right. I'm very sorry, but I do have to make a move now. So feel
Yes,
free
ma'am.
to email me if you have any further questions, and all the best. Please remember to have fun. Please remember that this is a learning process. Don't take it too seriously, and don't be too concerned about winning and losing, but really go out there and just do your best and have fun. All right. Thank you.
Thank you so much, ma'am, for being
Thank
here
you.
for the workshop. Thank you.
Sure. Bye-bye.
Nath ma'am is running a bit late, so we are going to take a break of half an hour and we'll resume at 12:45. So you all are requested to rejoin the same meeting at 12:45, and then we'll start with the drafting of plans.
Hi, good afternoon.
Good afternoon, ma'am.
Hi, good afternoon, Preet. Let me know when we can start.
Ma'am, we'll start in 5 minutes.
Oh, okay, perfect.
Good afternoon, everyone. Welcome back to the workshop of S.K. Mishra Memorial International Mediation and Negotiation Competition. In the morning, we had 3 sessions. One as an international perspective of mediation dealt with Justice 𝐒𝐔𝐁𝐄, then role of client and counsel, which was dealt by Miss Kathleen ma'am, and then role of mediator by Miss Linda Hing ma'am. Now in line, we have 2 programs. One is the drafting of plans, which would be dealt by 𝐒𝐂𝐑𝐈𝐁𝐄 ma'am. She's here in the session today. And then we'll be having a mock mediation session for you all. And at last, we'll be having a question and answer round with the OC, so that all of the doubts which you have, you can ask from the OC, and you'll be getting some general instruction of the competition. So to start with, I would like to request Jhalak to please give a brief introduction about 𝐒𝐂𝐑𝐈𝐁𝐄 ma'am. Ma'am would be dealing with the topic drafting of plans.
Ms. Kanath Pandar is an international law practitioner specializing in trade law and alternative dispute resolution. She began her career as a transaction lawyer at Sardal Amarchand Mangaldas, handling cross-borders, merger and acquisitions, private equity and venture capital transactions. Currently, she is pursuing graduate studies at the University of Cambridge and serves as a project manager at Cambridge Bourbon and an editorial board member at Cambridge International Law Journal. With the expertise in mediation and mediation advocacy, she, she specializes in resolving civil and commercial disputes. She also trains others in negotiation and mediation and actively coaches and judges international competitions. As a committed mentor, she volunteers as a moot court judge and focuses on areas such as international trade law, arbitration, mediation, negotiation, and technology law. Ma'am, we welcome you, Lord.
Thank you so much, Chalak, for that introduction. I hope we have all the participants joined online. And if I could request you all to turn your videos on so that this will be a way more interactive session. And I know who I'm speaking to. To start with, I believe you have the sample mediation plan. In case not, I'll see if I can share that in the chat. And we can start from there. How we're going to go about in this particular session is essentially look at a mediation problem from the past year. We use that as the base to understand that once you are once you are faced with a mediation problem, how do you first go through the problem to understand both sides of the picture, understand what is at stake for the parties, and really break down the problem, right? Because those are the first initial steps to understand how you take on a dispute. And then we see how do we put this down into either a mediation plan from the perspective of a mediator who's going to mediate the said problem, or from the perspective of each of the parties, that is the requesting party or the responding party to a dispute. So to start with, I'm just going to share the, give me a second. Yes, I'm just going to share the mediation problem with you. As you will see once this is visible on your screens, that I've highlighted particular aspects of the problem. As we go through it, you will understand that these have been highlighted from the perspective of what is relevant for each of the parties, right? So even in your cases, you would right now have a mediation problem that each of you would be working on as parties. Even in real life mediations, when a brief comes to you, there is a brief understanding of what are the agreed upon facts between the parties, and also specific facts that your particular client as a counsel would divulge to you of what is of importance to them. So let's go through the mediation problem that we have at hand, which is Gulf Haven. It essentially relates to a dispute between two parties, one being the Oceanic Energy Corporation, which is a MNC working in the oil sector. And the second is a local NGO, which is based out of the same place, that is the Republic of Minero, and works in the space of environmental protection. So as we see, I'm going to focus more on the highlighted parts because those are the parts which are most relevant from the perspective of understanding what is going on in the problem, right? So OEC, a multinational oil giant, which is the world's biggest oil company known for its vast resources and influence, was recently faced with severe backlash as one of its oil refineries leaked oil in the pristine coastline of Gulf Haven on 27 June 2023. This tarnished OEC's reputation, leaving the company in a bad market standing. However, OEC pledged to resolve this conundrum by agreeing to compensate the affected communities and coming up with a solution to save the marine life, which is the most affected. This gives us the context of what OEC does, how the particular dispute at hand started, that is with respect to the oil leak, and then we'll go into how has it impacted OEC and how it's impacted the other party involved, right? So first we see that OEC agreed to certain compensation to be paid and to come up with solutions in order to save the marine life and to save all the affected communities around that area. Now coming to the second party, that is the NGO. It's an environmental NGO of Gulf Haven, Guardians of the Gulf. It steps in to address the ecological and economic impact of the disaster. The NGO is famous for its heroic acts of fighting to save the environment and helping people in need. What we are getting out of this is the NGO's main focus and its interest is in order to protect the environment where it's working out of it. The NGO believes that the damage done to the environment in the communities living near the coastline has gravely affected the vast majority of them as they rely on fish farming and tourism. So fish farming and tourism become relevant from the point of understanding what are the potential areas where options and solutions can come up for both the parties and where we can see that both the parties can work together to help the communities that live nearby. Next, the oil spill wreaks havoc on local fisheries and tourism. On 13 September 2023, the NGO took charge against OEC and initiated an independent economic study for the losses suffered by the people. The study concluded by precisely evaluating the loss to be around rupees 35 crores. This finding caused a huge outcry in the public domain, further diminishing the reputation of OEC. The people living in the city took to the streets and showed their anger by protesting. Right? So all of this is with respect to what are the steps that have been taken by one party, that is the NGO, in understanding and assessing the situation of what the economic losses, which is around 35 crores, what has the impact been on the people and communities surrounding in that area. And this also shows how it's impacted the company, that is OEC, by diminishing its reputation. So reputational interest will be one of the factors that OEC will be considerate of. Now, going forward, to safeguard its reputation, OEC launched an aggressive public relations campaign on 30th January 2024, attempting to downplay the severity of this bill. They highlighted the efforts to rectify the situation. These efforts were respected by the international community. However, on the other hand, the NGO exposed the ground reality with real-time updates on the ongoing environmental damage, which helped them mobilize public support from all over the world for stricter regulations of the oil industry. This tussle made the situation worse and even more sensitive between the two parties. Now, coming down to, sorry, there's a lot of. If I could just request the OC, is there a way for me to mute? Because I'm getting a lot of notifications with people joining and leaving. which is distracting during the session.
Okay, ma'am.
Is there something that I can do from the settings so I don't get all these notifications?
You won't get any notifications.
Okay, perfect. Thank you so much. Continuing from where we left out, 𝐂𝐒𝐄 attempted to make numerous changes to the plan to lessen the damages, but because of the backlash on its reputation, they were unable to materialize any concrete solutions while desperately attempting to maintain its lost reputation and stay in business. 𝐂𝐒𝐄's stock took a significant hit as well, wherein a lot of shareholders ended up selling their stocks, which led to a downfall in the value of its share price. So we see there's a direct monetary impact to 𝐂𝐒𝐄, which arises not just from the oil spill, but also the after effects of how people reacted to it, of how the report from the NGO came out, and it showed that even the steps that 𝐂𝐒𝐄 was trying to take were not fruitful in terms of the final outcome. This led to a situation of distressed funds for 𝐂𝐶 and reduced the possibility of viable solutions to the environmental disaster. Which means even as 𝐂𝐶 as a party, you can do as much as you can if you have the resources to bring about the solutions. But with the stock prices falling down, it also limited what all they could do in terms of the solutions, speaking monetarily. Now, what I've highlighted in green is essentially third-party stakes which come into the picture between a dispute between two parties, which might not be relevant to the interests of the parties, but because they will have an impact on how the dispute goes, therefore that is something to be considered. That is, the national and local governments faced increasing pressure to take decisive action. People began showing dissatisfaction and contempt towards the government, which put tremendous pressure on the top governmental authorities. Some politicians aligned themselves with the NGO, advocating for stringent regulations and legal consequences for 𝐂𝐶, while others argued for a more lenient approach as they were allegedly 𝐂𝐶's political connections. Now, finally, coming to 8th June 2024, the NGO revealed a vital piece of information that suggested that despite 𝐂𝐶's efforts to contain the spill, the environmental damage continues to unfold and grow in magnitude. Marine life was getting severely affected, and the once vibrant coastline turned into a haunting reminder of the disaster. Real-time images of oil-soaked shores dominated the media and fueled public outrage. Now, in the background of this, the NGO has requested for a mediation for things to be resolved between both the parties. Now, let's get into what is it that the parties can do and prepare for the dispute when they have. Now we've gone through the whole dispute. We have understood what is the underlying issue. That is, on one hand, 𝐂𝐶, of course, is in the business of oil mining and wants to go ahead with this. But because of the oil spill, there is a lot of negative impacts of what they're doing in terms of the wildlife around in that area, the species living on the seashores, and also the communities in that in the country which have been impacted by the oil spill. On the other hand, the NGO, which is looking out for the environment and for the communities that have been impacted, wants some stringent action to be taken. So if we think more deeply about this, we understand that there is a lot of overlaps in terms of what both the parties want to do. That is to resolve the oil spill and also minimize the impacts of the oil spill, and going forward ensure how a similar situation does not arise, right, in the future. Now, to do both of these things, there are very different interests involved from both the parties, where 𝐂𝐶 as the company wants to ensure that their business keeps on going, and they also have support from the government where they're working, and they also have support from the local communities so that their reputation does not take a hit, which subsequently takes a hit on their business, and therefore this stock values and also the shareholders who are interested in the company. Similarly, the NGO wants to ensure that they come to a resolution, but from the perspective that the wildlife in that area is preserved, that there is some sort of a plan in position to ensure that not just right now, but in the coming years, they will be protected. Similarly, the impacted communities in the area who are really rely for their livelihood on fisheries are not impacted. They get some compensation monetarily, and it's a sustainable form of doing business for them where they do not have to fear such future oil spills, which impact their daily livelihoods as also their daily lives, which is very codependent with nature. Now, having that background in mind, we are first going to go into the mediator's mediation plan, right? Whereas this is a problem where if you were the mediator, if you've got this problem to deal with, how is it that you prepare for the mediation, right? So before we get into that, just to break it down for you, the mediator's mediation plan would essentially contain pointers for the mediator before going into the mediation, so that she can understand, okay, what is the problem at hand, what are each of the parties, right, in terms of understanding the background as we had highlighted in the problem, understanding what are the potential interests, seeing that what is the potential overlap where there might be a space where both the parties can come to a solution, and figuring out that what are the blockages in reaching that solution, what are the considerations that each of the parties would have where they might not be so open about making a particular offer or coming to a solution unless certain needs are met, right? Those are things that as a mediator, even though a lot of it would be contingent upon the information that the party shares with you during the mediation, but a lot of the preparation for a mediation, for successful mediation, happens before you go into mediation, is as a mediator understanding what is the information that the parties have already provided to you, and what can you do in terms of predicting that what are the parties' interests, what is it that you might need to push them to open up about certain things to be able to create that safe space for them where they understand that all these conversations are confidential and therefore they can open up. Now, going into the mediator's mediation plan, let me know once if you can just drop in the chat if you can see my screen. Okay. So the mediation plan for OEC and NGO, this is the mediation strategy from the mediator's perspective. Firstly, begin the mediation by introducing the parties to the basic of mediation. I'm sure in the sessions before this, you've been told of how to structure a mediator's opening statement to ensure that the parties know what is to follow, and the parties are also comfortable with the setting, know what is the process, know the basic fundamentals of confidentiality, impartiality, and mutual respect. Second is to aid in agenda setting. Essentially, the mediator will listen to the concerns and the interests that both the parties raise, that their client and counsel raises, and to really narrow those down to understand, okay, what are the agenda points which the parties will follow through during the session. This would include looking at, in this situation, possible common issues that could be either preventative measures from the oil spill, looking at community welfare, and third, looking at from a future perspective of what could the regulatory reforms be, which work for both the parties in this case. Thirdly, facilitate the mediation process. This deals with the whole of the mediation process. That is, after your agenda setting, getting the parties to open up, taking one issue at the time, discussing them, really fleshing out the points, seeing what are the possibilities of options, pushing parties to be open to know that nothing that they say will be prejudicial against them or they will be bound by it unless they actually enter into a final settlement agreement. Therefore, really getting the parties' creative juices to flow and to think outside the box of what can they do to settle this dispute between them. In this case, it'll, as the mediator has written down, which will help us understand the differences between both the parties on first impact of the damage on environment. That is, what is the impact of damage on the environment from each of their perspective. For OEC, what does that mean? Is it that they need to put in more money? Is it that their future funders and investors will be more cautious in doing business with them going further if they know there is so much negative news around them, if they know that this is how their business has been impacting local community, and therefore they would question whether OEC will be able to continue doing business like this in the long run. Similarly, for the NGO, because environment is the number one priority, whether the way that they deal with the damage of environment, if it's satisfactorily to what they want. Second is understanding responsibility and liability regarding the oil leak. Who will take liability? Therefore, how much money should they put in towards the solutions? How much time, how much resources should they be putting in? Third is the legal resolution and public accountability. Remember, public accountability is not just from the NGO's perspective, but also for OEC, because OEC has, in terms of interest, a huge reputational interest at stake. It has reputational interest also from their stock price value at stake, where they need to come out at the top of this particular dispute to ensure that while taking accountability, it does not impact their corporate reputation in the market. But at the same time, it shows that they're willing to work together to resolve this issue, while also showing their commitment to their current shareholders and to their other corporate partners. The mediator will then facilitate a possible solution. Lastly, if the parties come to a common agreement, the mediator will draft a fair written agreement using a clear and neutral language. So the first part, that's the mediation strategy, in very brief, gives out what all the mediator plans to do during the session, what are the interest points, what are the considerations and factors of the parties that the mediator needs to keep in mind. Next is the goal of the mediation. This is for the mediator to really think, okay, I see this is the dispute between me, these are the parties, these are the interests. What do I think would be a fair settlement that might look like? What do I think I want out of this mediation, so that the parties are able to reach some settlement, are able to reach a space in their conversation where they're looking more eye to eye, are on the same table, looking at how to increase their interest, how to ensure that the pie grows bigger for both of them. The goal of this process for the mediator looks at allowing both parties to resolve the disagreements present between them and find a common ground. Second, how can the people who are affected by this spill be compensated and to help them? Third, how can environment sustainability be promoted to avoid future disasters such as the oil spill to minimize the harm that took place? If I were the mediator, I would also add aspects with respect to the emotional and reputational components involved on both the sides, where as the owner of OAC or the director of OAC, I would also look at what is the trust building exercise that I want to have with the NGO, or the NGO would look at, okay, it's not just that I want OAC to promise me to put in so and so amount of money so that these damages are taken care of, but also how do I build this as a lasting relationship so the next time an oil spill happens, I don't have to face a similar situation. Similarly, for OAC to ensure that the next time that the NGO feels that what I'm doing in terms of solution is not working out, the first thing that they do is not to carry out a report or a study on their own and make it public that directly impacts my reputation. But the first thing is for them to make the study and discuss this with me, so that that trust that we have built through the process is also something that we can keep working on, and which will make any solution that comes out of the mediation more sustainable for both the parties. Now, the next part of the plan is alternative means to achieve the goal. The idea is to look at what are the other alternatives open to both the parties. And this is part of the reality testing that the mediator needs to do. Of, okay, whatever we might agree to or disagree with over here, what are the other alternatives available to the party? And given these alternatives, given the reality of the situation, what is it that an ideal solution would look like for the parties? So, as it says, if the parties did not find any way to proceed with the problem, then OEC and NGO can come to a compromise where they both agree to collaborate on a project where they're willing to reduce the damage done on the island. Else, a neutral third-party environmental body could be established to overlook after the disaster and how the island and natural environment can be recovered and reviewed. Lastly, if both the parties are not satisfied with even both of these solutions, then the OEC and NGO can go to the ground directly and engage with the local people who are directly affected by the oil spill. So these are essentially other ways in which either the parties can collaborate together to come to a solution, can either trust a third party who can help them get there, or really see what are the other means where they can start working with other third parties and ensure that they're still reaching the goal that they want to, even if they're unable to do that in a more collaborative manner by always sitting on the table together. The next portion is very important because it breaks down the needs and interests of both the parties. That is OEC as the responding party, their reputation management, financial stability, and regulatory compliance, because all of these are interests not just to the current dispute, but also to the greater interest and need of how their business will work going forward and how it will work with the community and the country that's based in. Similarly, for the NGO, these needs and interests look at environmental safety, community welfare, and corporate accountability to ensure that these things of either an oil spill or the damage that pursues after that does not happen in the future. Next is your Batna and Vatna. Before I go into Batna Vatna, I will just like to explain the concepts and then we can briefly understand Batna Vatna in this context. Batna is essentially the best alternative to negotiated agreement, and Vatna is the worst alternative to negotiated agreement. A lot of people understand this to mean the worst and the best thing that you can agree on the table, but that is not the case. When it says negotiated agreement, it means any sort of solution, whether it's good for one party, bad for the other party. It can be anywhere on that scale of it's really great for one party or it's really great for the other party. Anywhere on the scale, if the solution is reached, that's a negotiated agreement. That means that the parties have gone into the whole mediation process, they've negotiated with each other, and they've reached an agreement of what they want to do. It might be a 75-20 agreement, it might be a 50-50 agreement, it might be an agreement which makes it the best of both worlds for both the parties, right? Either way, it is a negotiated agreement. Now, when we're talking about BATNA or WATNA, it means what is the alternative to a negotiated agreement, which means a negotiated agreement out of the picture. The parties have decided that there is no way that they can collaborate or work together or come to an agreement together, which means if as a BATNA or WATNA, the basic assumption is that if you're assuming that the other party is not cooperating with you at all, nothing that they do is in your favor, then what are the other alternatives that are present to you in order to resolve the dispute at hand? That is, with respect to your interests and needs, what is the best thing that you can do, or what is the worst thing that can happen to you if there was no agreement to be reached at this table, right? Which means you look at all the alternatives outside the mediation table or the negotiation table. What that would look like is essentially the best alternative for OAC would be that the NGO takes them to court, the NGO does not win in that dispute, right? And therefore OAC is not made to pay for all of this, and it goes forward, right? All of this, the best alternative, essentially think of it as a fool's paradise. Everything that can go right will go right for you. The worst alternative is more as more of the worst that can happen to you will happen to you. That is Murphy's law, and then you see what you can do with that, right? The idea of the best alternative and the worst alternative is outside the negotiation. What is your best and worst case scenario? And given your best and worst case scenario, is there a solution that you can come to over here which is better than those, right? So for OAC, the BATNA would look like that the OAC moves to court against the NGO, and the NGO can launch campaigns to rectify the bad image of OAC as part of improving its lost reputation. Also, OAC will rehabilitate the affected communities as well as the fisheries. These are things that it can do in order to ensure that it as a company, because it's getting so much public backlash, can still go on. But the best alternative to the negotiated agreement for AC is still that they win a court dispute, and then they do whatever they have to do in terms of resolving the oil spill on their own, right, without the NGO support. Similarly, for the NGO, it is that they win the court case, they get OAC to pay up for all the rectification of damage that has happened, and then they see what are the other changes, either legally that they're able to convince the government to get some laws in place and regulations in place which ensure that's mandatory for a company like OAC to carry out certain pre-dispute, not even pre-dispute activities, but rather pre-spill activities, wherein it ensures that a spill does not happen in the first case, or if a spill happens, what are the immediate steps that OAC or a company like it needs to take in order to reduce the impact of that spill. Similarly, the worst alternative would be everything going to the other end, right? Which means for OAC, they lose in court, they have regulations that come against them, they have local politicians going against them, the community that they're working in does not support, and the stakeholder value only goes down, right? The shareholding and the valuation of the company goes down and really takes a tank. And then OAC has to say, okay, what is it that I would have to do in such a situation to get out of it? For the NGO, the worst alternative would be that OAC does not have to take any liability. They need to keep carrying out this work on their own. They need to figure out where to get funds from. The government thinks that's not a case where they should be over-regulating, so they do not help with regulations or bringing out a legislation. So literally the NGO is left on its own to figure out what is the way going forward. So those would be the BATNA and WATNA situations for each of the parties from the mediator's perspective. Now I'm going to take you to, give me a second. Yes. Now I'm going to take you to the mediation plans from the perspective of the party. So first we are looking at the negotiation plan for the NGO. The first aspect is dividing what will be the roles and responsibility of the client and counsel. Remember, it's a two-party team, so you need to be very clear of what are the things that a client would say and what are the things that a counsel would say. In a competition setting, what works really well, at least, is dividing your opening statements where the client goes off and then the counsel. and there's a little back and forth, so that there is that bonhomie between the two parties that can be seen from a competition perspective, right? Even from a non-competition perspective, what works really well is understanding that these are the interests, and these are purely commercial interests, these are purely option-based interest, which should come from the client, right? Because the client knows their business well, the client knows what are the absolutely integral parts of how this dispute has impacted them and what they need to change about it. Similarly, the council needs to be there to protect the client's interest, to always be on the lookout of what's happening in the discussion, to point out certain interests of the clients where it feels that during the discussion that their clients' interests have not been highlighted, right? Or have been taken a backseat, or during an option session, if while discussing a solution, the interests have not been taken to the forefront. So that's how you divide the role and responsibility between the client and counsel, which I'm assuming you've gone into a lot of details before this. So in the mediation plan for the parties, you will first divide, okay, what are the aspects of the problems that you'd like the client to deal with? What are the aspects that you'd like the counsel to deal with? Also be clear that the counsel needs to be looking out for the client rather than taking on a leading role of really driving where the conversation goes. Council also needs to really create the supportive space where it's able to get their client to really think of more creative solutions. Understand that when there are trade-offs in interests, where the client is ready to give something to get something in return from the other party, really helping the client understand what would that mean for their other interests, and having a really big picture view in mind, right? And at the same time being understanding and also aware of what are the legal risks, what are the potential issues that might come out of any particular solution, right? Really, sometimes you have to play the devil's advocate as the counsel to ensure that your client is very well protected, while also being aware of what a Vatna and Bhatna would look like. And when needed, really push your client to think outside the box, think of the solutions that they can come up with, because those solutions will always be better than the alternatives outside of a negotiated agreement. The next part of the plan deals with the underlying needs and interests of the competing parties. As you would see, a lot of this is similar to what we had done while reading the mediation problem. So I'm just going to stick to the negotiation plan of one party, which will help you understand similarly how to frame the other one. Is first you take the needs and interests of your own party, right? That is the NGO. So you look at the need of the NGO is to take responsibility for OIC to take responsibility for the damage caused and compensate the impacted communities to the value of around 35 crores, to work with OEC in proposing viable options for alleviating the effects of the oil spill. The interests underlying these needs are essentially a genuine desire to protect coastline communities and the marine environment, the desire to upkeep their reputation as environmental heroes, and encourage the government to impose stricter standards on oil companies. Now, this is essentially, as the party, you see what is it that's important to me, right? What are the needs? What are the underlying interests which drive these needs? Is it, why do I want OAC to take responsibility? Why is it important for us to work together and come up with solutions, right? What is the basis for all of this for me as a party? What is my why that's driving me? Why do I want them to do this, right? Now, similar to the task, which is easier said than done, is for you to do this for yourself as the party. Also, to prepare for mediation, you do it for the other side. You see, okay, for the other party, what are their needs and interests? What really drives them to collaborate with me? So, for needs, we have listed down restoring public opinion of OEC and gaining NGO support in the public, which is their reputational side and also the shareholder value side. Technical assistance and a financial support from the NGO or a third party to generate more solutions to the oil spill. Third, preserving the environment, possibly through other methods to build CSR and improve relationships with NGO. This is thinking outside the box, that what is it that if I'm a company, what are things that I can do which also benefit me monetarily, but also benefit the communities that are impacted by my actions. Then it's looking at the interests, is managing its reputation after the economic study and real-time updates of Gulf Haven's environment were released, be allowed to continue operations in the region in the long run, restoring its share price and the relationship with various stakeholders such as the NGO, government, and citizens. Ideally, how I would like to really draft this and strategize it is, what you can do is, instead of just listing them down as needs and interests, you can also make two columns, right? Wherever there's a need, there is an underlying interest for it, right? What is it being derived from, right? So what you can do is list down the needs, and then list down the interests in the other column, which basically correspond to those needs, because it makes it more clear for you in your head of all of these map, this whole mind map of things of what are the needs and interests. See what are the connections that you can drive of interests and needs, because that will really help you understand what is it that's driving the other party, right? When you understand that, you can see what are the potential spaces for solutions, what are the potential spaces where you can collaborate, and where you can remind the other party of, see, I understand that this is an important need for you, so why don't we think about this particular solution, because not only will it work for me in ABC ways, it'll also work for you in 1, 2, 3 ways, and really resolve one of your interests, right? So really having a collaborative need and interest breakdown is very helpful from that perspective. Next is identifying obstacles and means to cover it. You essentially see what are the obstacles that I as an NGO can see. And as this has been done, you see the obstacle, then you figure out and really brainstorm what would be the means to overcome such obstacles. So let's just take the example of one. Incorporate our suggestions into legislation to minimize the likelihood of such devastating events. The means of doing this would be to offer a mutually beneficial solution where you are taking into consideration the corporation's need. That is, you can't just have a legislation which bans all oil operations, but you can have a regulation which ensures that there are greater regulations that are set down of these are the 1, 2, 3 minimum things that the company needs to do before it starts its operation. These are the environmental impact analysis that needs to carry out. If there has been a oil spill, or even if there is a potential of an oil spill, because it tends to happen in such operations, have a fund in place already, right? And having something of this sort, you can also look at, there's a potential solution of really advertising and coming out with a public notice with the NGO as a party, with the government as a party, where they're saying, okay, we as an industry leader will take lead of setting up this fund, and we would hope that all the other companies will follow, right? Or if it's through a regulation that we want to support, and we have suggested this to the government that this is what should be done as a CSR initiative, is to set up a fund for rehabilitation of those who have been impacted by oil spills, and ensure that through the regulation even other companies follow it, right? Which means multiple interests of OEC have been met, where they're dealing with the oil spill, they're dealing with their reputational damage, they're dealing with how to ensure that this does not happen in the future, which is more of an interest for the NGO, and for the third party, that's the government and local community, but it benefits them because they'll be able to carry out their business without any of these obstacles in the long run. Coming to Bhatna and Vatna, as you'll see, it's very similar to what we discussed in the mediator's plan, so I'm not going into a lot of details. But Bhatna for the NGO would be they're able to successfully lobby the government, able to get stricter oil regulations, get penalties on OEC. Similarly, the worst alternative for the NGO would be it ends up with the government ends up siding with OEC's efforts instead of their own, and assist them in clearing their reputation, which does not work to the favor of NGO, right? So that's largely it. Similarly, I think you already have the mediation plan for the other parties. I'm not going to go through it, but the whole idea of going through each of these plans and to go through the whole problem was to ensure that you know how to deal with the problem, what are the things that we're looking out for, and how do you put them down into a plan, so you know exactly how to be prepared for a mediation. Remember that a mediation is, at the end of the day, different parties coming together, so we can prepare very well for it, but how the actual conversation goes, a lot of it will depend on the parties, will depend on the agenda that is set and the conversation that follows through. So with that, I'll be ending my session, but if there are any questions, I'm open to that. And if I could request Chalak to really help me in collecting questions. So if there's either on the chat or if there are any hands raised, let me know.
If you have any question, you can just raise your hand and unmute yourself.
Hello, ma'am. Good afternoon. Ma'am, I have this one question regarding the entire drafting of plans, right? So in case we draft these plans, right, let's say we get a confidential information which may contradict the set plan, right? How would we deal in such situations during a mediation? Because that may require us to completely pivot to a different solution altogether. So could you please shed light on such aspects and such situations, ma'am?
Sure. So the underlying aspect of your question is essentially that I have done all my homework, right? I have put together what is it that I expect the mediation to look like. Remember, as I said, that is humans will be sitting on the table and speaking to each other. And depending on how that conversation goes, it need not be exactly how you planned. So there will be a lot of thinking on the feet involved, which is you understand from your confidential information, how is it that the interests, either your own or the other parties, that have changed. Therefore, before you go into the mediation session, you look at your confidential information, you see, okay, what are the things that have changed for me, right? Have that in mind. Rest is, remember, you can do all of this planning, but active listening is the most important part of a mediation, that you're really listening to what the other party is saying, what the mediator is saying, and accordingly responding. So you don't have to be constrained by your mediation plan, rather use it as a guiding light, but always remember that you have 2 years and 1 month for a reason. Listen to what the other party is saying, and then accordingly see how you want to go ahead. Don't just listen for the sake of responding to that. So always just think on your feet and go ahead with that.
Thank you, ma'am.
Thank you.
Anyone else? Do you have a question?
Okay, if we don't have any further questions, you can contact me on the given below details and I'll be happy to answer. And thank you so much for having me.
Thank you so much, ma'am, for your valuable insight. We were very happy to have you here in the workshop, and thank you so much for being here.
Perfect.
Now,
Thank you. Have a good day.
Now we have a mock mediation for you all. I would request the mock mediation team to please switch on their cameras. And rest OC to just switch off your camera so that all the mock mediation team is visible.
Shall we start? So good afternoon, everyone. I am Sneha Madan, and I'm from Lloyd Institute of Mediation and Arbitration, and I welcome you to this mock mediation session. Today, we will be conducting a structured 40-minute session based on a complex environmental dispute between Guardian of the Gulf, a prominent environmental NGO, as the requesting party, and Oceanic Energy Corporation, or OEC, as the responding party, which is a multinational oil company. This case arises from a major oil spill that occurred on June 27, 2023, along the coastline of Gulf Haven. This spill, originating from one of the OEC's refineries, caused significant damage to marine life, fisheries, and tourism, severely impacting the livelihoods of the local population. Despite OEC's pledges to contain the damage and compensate affected communities, concerns remain about the adequacy and effectiveness of these efforts. Tension escalated when an independent economic study conducted by an NGO estimated the financial losses suffered by the people to be rupees 35 crores, triggering public outrage. OEC, in turn, launched a public relations campaign to mitigate reputational harm. With legal battles expected to be lengthy and resource intensive, both parties have agreed to explore mediation as a means of finding a constructive resolution. This mediation session will focus on identifying key concerns, exploring possible solutions, and working toward a mutually beneficial agreement. With this, I pass the floor to the mediator to begin the session.
Good afternoon, everyone. I hope you all are comfortable. I would like to welcome the parties to this mediation session. Allow me to introduce myself. I am Ananya, your mediator for this session, and this is my co-mediator, Siddharth. I would like to thank both the parties for choosing us as your mediators today, and would also like to tell that we both are AppCam certified mediators and hold 10 years of experience each in environmental and international law. The parties can feel free to address us by your first names. Now, I request the parties to kindly introduce themselves.
Hello, everyone. My name is Vikrant Rawat.
And here I am a capacity as the Executive Director of Guardians of the Gulf, an NGO, and I will be capable of taking each and every decision.
Good afternoon, everyone. I am Sneha Madan. You can call me by my first name, and I'm the counsel for Guardians of the Gulf. And my role here is to assist my client throughout the session and nowhere near to taking any decision on their behalf.
Good afternoon to one and all present here. I am Anshika, representing OEC as its CEO. You can call me by my first name. Each and every decision in this mediation process, I'll be solely responsible and have authority over every decision.
Good afternoon, everyone. My name is 𝐒𝐔𝐁𝐄, and I will be acting as the counsel for OAC. I am here to guide my client throughout all the legalities of this session.
Thank you, parties. So before moving further, I would like to first congratulate both the parties for amicably resolving their issues and voluntarily choosing mediation as the resolution, where all the information will be confidential, rather going for litigation. So before moving further, I would like to ask that if the parties present here are fully competent to take any decisions and sign any agreement during this session? Yes.
Yes.
Great.
Good afternoon, everyone. Mediation is a totally voluntary process in the sense that parties cannot be forced to agree to any settlement which they are not comfortable with. They can leave the mediation session at any point of time. The confidentiality is of utmost importance to this forum. Therefore, anything said within these four walls will not leave the room and cannot be used against the person in a court of law. Is this your first mediation session?
Yes, it is.
Okay, just to bring uniformity to this session, I would briefly explain the stages of mediation. Mediation process involves 4 stages. Firstly, the opening statement, joint session, then there will be private caucus, and lastly, agreement. In opening statement, the parties will brief the present case from their point of view and will be formulating agendas according to their opening statement. And agendas can be added and removed by the consent of parties. Joint session. In this stage, parties will collaborate, negotiate a workable and amicable and mutually acceptable solutions. Private caucus. If the parties come to a deadlock or negotiations has broken down, then we can call for a private session where we will talk with both parties individually in the absence of other party. It will be totally confidential and any information can only be disclosed by the consent of the parties. Our role as a mediator is to aid, facilitate, and remove deadlocks, oversee the decorum is maintained, seek clarification, and will remain neutral throughout the session. Now, mediator will give us some ground rules.
Although parties, mediation is a bit informal process, but we must adhere to some ground rules. I request the parties to maintain the decorum of the session. Please be patient and do not use any inappropriate language in the session. Lastly, the current session will be governed under AppCam rules and regulations. Now, I open the floor for the requesting party to start with their opening statement.
Good afternoon, everyone. My name is Vikrant Rawat, and as I stated earlier, I'm the Executive Director of the Guardians of the Gulf, an environmental NGO dedicated to protecting the marine ecosystem and the livelihoods of the people of the Gulf Haven. It is such a wonderful day to have this fruitful discussion, and I hope you all are being at very good health also, isn't it? Yeah, great. First and foremost, we want to acknowledge the significance of this mediation. This is not just about a business negotiation. It is about accountability, responsibility, and the well-being of an entire community that has suffered immensely over the past. We are not here to dwell on past mistakes, but we cannot ignore the fact that the families have lost their primary source of income. Marine biodiversity has been severely affected, and the trust between OEC and the people of Gulf Haven has been deeply eroded. However, as we come to the table today, I promise that we are committed to find a solution that serves the best interest of both the parties, while remaining mindful of our respective interests. As an organization that has worked tirelessly to safeguard the environment and the backward communities, we have seen the struggles of those affected by the spill, the losses of fishermen, as now they came empty net. Local businesses, once flourished due to vibrant tourism sector in our country, have shuttered now. We acknowledge that OEC has taken steps to address this crisis, and we appreciate the efforts that they have made. However, we must be honest about where the thing stands. More than a year has passed, and the damage is still unfolding. The oil may not be visible on the shores anymore, but its impact remains in the water. Rebuilding trust takes more than the words. It needs real action. That's why we are here today. Our position is simple. As an NGO working for the people of our nation, the people of Gulf are our utmost priority. The people of Gulf Heaven need and they also deserve financial relief. Compensation is not just a number. It helps families find stability, business rebuilds, and the local economy recover. We value open and honest communication. We are not here to be adversaries. We are here to advocate for those who do not have the power or the platform to sit at this table. We believe that together we can develop a solution that not only mitigates the disastrous impact, but also foster long-term environmental responsibility. In the end, this is not just about financial compensation. It is about restoring dignity, rebuilding trust, and ensuring that the people of Gulf Haven can once again look to their future with hope. With this, I pass over the floor to my counsel.
Thank you so much, Vikrant, for explaining our stance so well. First of all, I would like to thank the mediators for setting a positive stage for this mediation session. And then I would like to thank the other party for coming on board and committing their time for this session. So as we are here today, because the real harm has been done, harm that continues to impact the lives of people who did nothing to deserve it. The oil spill was not just an unfortunate event. It was a devastated livelihood, disrupted ecosystem, and shook public trust. While we appreciate OEC has made efforts to address the situation, the question is, are those efforts enough? As Council for Guardians of the Gulf, we believe in solutions, not stances. Our goal is simple, to ensure fair compensation for the affected communities. Along with that, a solid enforceable plan for environmental restoration. We're not here to dwell on blame. We are here to make sure that what's been lost is acknowledged and, more importantly, restored. OEC is a global leader in its industry, and with that comes responsibility. Corporations operating in high-risk sectors must not only take preventive measures, but also act decisively and fairly when things go wrong. We are prepared to negotiate in good faith, guided by principles like restorative justice and proportionality in compensation. At the same time, we remain steadfast in ensuring that the rights and interests of the affected stakeholders are not diminished. We look forward to a constructive dialogue and trust that this mediation will serve as an opportunity to establish a precedent for responsible corporate conduct and equitable resolution. At the end, we are here to have an open, constructive conversation. We are open to hearing solutions, but we are also here to ensure whatever comes out of this process is meaningful, enforceable, and genuinely committed to making things right. With this, I would like to summarize our key interests while coming to this table. First, financial compensation. Second, environmental restoration. And third is public accountability. With this, I pass over the floor to the mediator.
Thank you, Sneha. So now I request the responding party to please make the opening statement.
First of all, I would also like to thank the mediators and the requesting party for inviting us into this mediation process. As stated earlier, I, Anshika, am the CEO representing OEC. We understand that The oil leakage was an unfortunate act, and we own our liabilities, and we are here to rectify it. We are also here to answer the questions the requesting party has for us. During this mediation process, we hope, we believe, and we understand that um, it will turn out to be a favorable condition for both of us. Both of the parties reach to a midpoint where both of the parties are satisfied. With that, I want to give the floor to my counsel.
Thank you, Anshika. First of all, I'd like to thank the mediators for running us through the whole process of the mediation. And I'd also like to extend my gratitude to the requesting party for choosing mediation as a medium to solve this problem. We believe that the NGOs and our companies' interests align, and we both aim to achieve the same goals and secure similar interests, such as the compensation for the individuals affected by this mishap and restoring the marine life of the Gulf. We hope to have a smooth session and come to a common understanding as soon as possible and to get to the bottom of this dispute. We believe that we can secure the interests of both the parties and restore our reputation in front of the general public. I hope we can all agree that the restoration of the marine life and the general public is of top priority. So let's continue with this session. And while keeping these priorities in mind, let's come to an amicable solution.
Thank you, parties, for your opening statement. Based on your opening statement, we have formulated 3 agendas. The first will be finance, the second will be environmental restoration, the third is future relation, which also includes affected reputation of both the parties. Do we agree on these agendas, or would you like to add or remove something from the agenda? All right. So agendas are flexible. So let's start with our joint discussion. We will first start with the requesting party.
Given the complexities of the events leading up to and following the oil spill, we would like to understand OEC's perspective on how this incident occurred and what were the measures in the place to prevent such an incident. Understanding these aspects will help us to gain clarity on the underlying causes and ensure that similar incidents can be prevented in the future.
Yes, Vikram. We maintain our machineries and keep a regular check to prevent any accidents. And we have been doing this for past 30 years without any failure. It's just this time, for the first time, that one of our old refinery leaked due to some external issues and contaminated the marine water. We own our liability, but we want to assure you that when we got to know about the mishap, it was truly too late for us to stop. And if we would have got to know about it much earlier, we would have definitely taken immediate actions. The question you asked about the precautions. We deployed emergency response team and specialized equipments to contain and clean the oil spill promptly. We are ready to help the affected communities as well. We are keeping a track on the cleaning process so that it can be resolved as soon as possible. We have reviewed safety measures for preventing future spillage. If you have any other queries, we are ready to answer. And with that, I think my counsel has something to say.
Thank you. I would like to extend my client statement a little further and get a little insight on the technicalities. I would like to assure you that we hadn't left any room for mishaps like this to occur, and once we got to know about the leakage, immediate measures for the clearing of the waters were taken up. We are currently trying to get to the bottom of the reason for the leakage and would come to a conclusion soon enough. Therefore, we as a company would like to know further about your interests and would prefer a deeper understanding of your primary concerns about the event. And as the counsel for OEC, I would like to ask the requesting party to kindly provide a deeper knowledge about their primary concerns regarding the whole event. Thank you.
Amitosh and Anshika, our primary concern is our people. And for them, we need compensation package of rupees 4 crore for affected communities. We believe that rupees 4 crore is the bare minimum amount required to restore the affected communities. Given the scale of economic disruption, this figure is both reasonable and necessary. We believe OEC, as an industry leader, understands the meaningful reparations are not just about financial relief, but also about restoring the public trust and credibility.
For explaining the proposal, I would like to to justify the amount which we have proposed. So the spill which happened has directly impacted the fishing and tourism industries, leading to significant loss of income. And the compensation, as you know, is a legal and moral obligation under environmental liability principles. And our assessment which we have made indicates that 4 crores is the bare minimum required to restore the affected community. Given the scale of economic disruptions, this figure is both reasonable and necessary. We believe OEC as an industry leader understands that meaningful reparations are not just about financial relief, but also restoring public trust and credibility.
Okay, so I think what they are trying to convey is that, and correct me if I'm wrong, is that people are affected by this oil spillage. And they want to know what is the quantum of amount that you are willing to pay them for this harm caused. Am I right in saying that? Okay, up to you, responding party.
As we are a business corporation, we have calculated the funds we can provide for the compensation. We think that because of the calculation and we have to restore the marine life as well, we won't be able to give 4 crores as compensation. What we can do is we can settle on 3 crores because we have to restore the marine life as well. And we want that to happen without any other mishap. So can we settle on 3 crores?
The amount which we have mentioned is reasonable and justified. And for that, I think we would like to take caucus.
Sure.
So I request the responding party to kindly wait in the to kindly leave the room and may feel free to join the room after just 5 minutes.
Team, do you want 𝐒𝐔𝐁𝐄001? Have they left the session?
So, mediators,
Yeah.
OEC is the largest oil company in the world with vast finances and operational resources. And at this point of time, our people are suffering. We are the adverse parties. If such a corporation, such a big corporation like a OEC claims to lack funds for a disaster it caused, what message does that send to the global community about corporate accountability? We need the compensation for our people to resettle them for infrastructure, and the rest of the thing will be told you to by my counsel.
Okay. So we think to the caucus, we wanted you to understand that the amount which we have set is justified. And as you know, and the party also very well knows that the amount which we calculated about the losses was 35 crores. We have already came down to 4 crores, and which is the bare minimum amount which our people deserve. As I said in my opening statement, this is not we did nothing to deserve what all happened. And that's why, and I truly believe as a council that public trust and investor confidence are directly tied to how a company handles these crises. And if OEC fails to provide adequate relief now, the long-term financial losses through lawsuits, regulatory actions would far exceed the cost of compensation. And that's why I want you to emphasize that the amount we can't lower down it, and if they have any financial issues, we can fix them while talking about other agendas.
Okay. So do we have the consent to disclose some of the information that you have provided us? Okay.
Yes.
Just to confirm once again, we'll have to emphasize on the point that you cannot lower down the amount anymore because it is to, recover all losses which has been recovered or which has been made. already 35 crores, like amount of 35 crores losses have been done. So now we have been settled on 4 crores, which cannot be lowered down. Am I right?
Yes.
All right.
Should bring the responding party.
Is there anything else which you like to tell us?
No, thank you so much.
Okay.
All right.
Then we would bring the requesting party.
Team, if the other party wants to take the caucus, please let us know. We'll put 𝐒𝐔𝐁𝐄 003 client counsel in the breakout room. They don't need to leave the session.
Okay. Will you just bring the responding party back in the meeting? Yeah, thank you. So we have taken a caucus session with the requesting party. Now that they have taken a caucus session, would you also like to take a caucus session, or would you like to continue with the session?
No.
I think we would like to continue with the session.
Okay, thank you. So what they have told us is that they have incurred a loss of 35 crores, but they are ready to settle on the amount of 4 crores. And the public, there is a huge trust issue between the company, OEC, and if they give a good amount to the people for settling, then it will be beneficial for them because it will improve your public relation and it will help you in your stock price and other financial issues. What are your views on that?
Thank you. As we are on a financial constraint and we have limited funds, and we planned earlier that we are going to give certain amount for compensation and certain amount for restoring the marine life. We somewhat agree, we are agreeing to increase the compensation by 1 crore. But the one thing I want to add to it is that we would like to avoid any other kind of financial pressure, because as I have stated earlier, we are on a financial constraint.
Can mediators summarize what the client Anshika has said?
Okay, sure. So what they're saying is that they will increase the amount from 3 crores to 4 crores, but they are not ready to incur any further loss or pay any further amount because their companies is also in financial constraint. So they will be only able to pay this 4 crores, nothing more.
I am okay with this.
Okay. So I think we have reached to an agreement.
I think I would really like to appreciate the other party for agreeing to the proposal. And now we think we can move to the next agenda. And with that, I will pass the floor to my client.
Okay. The next one was environmental restoration. Then what do you think? How can we restore? What is the framework for that?
We agree that this bill has severe effects on the marine ecosystem, and any short-term cleanup measure are simply not enough. We are going to commit to a structured, transparent, and long-term environmental restoration plan in collaboration with independent environmental experts and local stakeholders. We want the people of Gulf Haven to know that their waters and shores will be truly recovered. Thank you.
Okay, so what I can collect is that you are very considerate enough to not employ any short-term process, but to employ a long-term structured infrastructure process to restore the losses of the marine life, which has already been caused. Am I right, Anshika?
Yes.
Do the requesting party agree with this, or do you want to add
have
anything?
something to say,
Or do you have a
mediator?
counter?
Yeah. We appreciate that OEC acknowledging the need for long-term restoration. The people of Gulf Haven has been living with the consequences of this bill for over a year, and they deserve an action plan. that is not only well structured, but also independently monitored and publicly published. We must set clear milestones, a timeline, and we want to emphasize that the local stakeholders and experts must be a part of the decision-making process.
I really appreciate the proposal made by the other party, and it's a very good proposal, but I would like to emphasize on the ways how we can make it better. So while OEC's willingness to propose a structured remediation plan is a step in the right direction, our concern lies still in the accountability and enforceability of this proposal. So I would like to address and discuss how the plan will be codified into a binding framework, ensuring that regular third-party audits and public disclosures. With that, I want to emphasize that accountability and enforcement should be there, and that the plan should be legally binding with penalties for non-compliance. And second, should be third-party audits and transparency, which means that independent experts should monitor and verify the progress which has been made in this project. With that, we would be employing legal mechanisms, considering the MOUs and enforceable agreements that incur funds to ensure compliance. These will be some things which are essential for us to establish accountability.
Okay, sure. Does the responding party agree to this proposition?
We certainly do agree, and as I would like to extend the statement, we will give assurance that we will take all the preventive measures to avoid any mishap in future, and we will try our full to rectify the situation. We are holding the liability that it happened, but for the future relation, we are going to appear in public, and we are going to accept the liability.
So I think the responding party is trying to convey that they will be a public accountability for their action, willing to employ a mechanism, and will be willing to accept the proposition which has been by the party. Thank you.
Okay, I totally understand, and I also agree that a public commitment to stronger environmental safeguards is not just about Gulf Haven, and it's about setting a precedent for responsible corporate conduct. And I think that this will help both of us to rebuild the trust. The bridge which has been broken by this event will be rebuilt with this public acknowledgement, as well as the proposal of long-term stability and long-term reinforcement plan.
I think we have tackled this point of contention as well. Should we come to next agenda, or do you want to continue with this?
I think we can proceed to the next agenda.
Okay, thank you. The last one was future relations and the reputation that was affected of both of the parties. So let's discuss about that. First, let's hear what does the requesting party has to say.
I think the agenda, the interconnected and the spider webs. So as we have addressed the point of public acknowledgement and establishing a long-term plan, we have already addressed the agenda of long-term relationship. And as the OEC has claimed that their reputation has been tarnished, so if there's anything which they have in mind from us to fulfill that agenda, they can go with it.
Okay. Does the responding party have to say anything?
Yes. I would like to point out that since we are working together, the NGO and the company, to restore the reputation of our side, there shall be no remedy, there shall be no restrictions from us, and our top priority would be to solve everything about this mishap and get to an understanding about the solution.
Okay. Is there anything requesting party would like to add? No. Then I think we have accomplished all the agendas. Do we like to discuss anything further? Any additional information that you would like to add? Okay. So
I think that we have reached to an agreement where the compensation of 4 crores will be given by the OAC for their losses, for the losses which have been made, which have been occurred due to the oil spillage, Second, there will be a structured infrastructure plan will be employed with legal sanctions on non-compliance. And third, regarding the future relations, which the OAC is willing to be held public accountable for their actions. Am I right on this? Great. So this agreement would be binding on both the parties and will be signed by them. So I congratulate both the parties for reaching this agreement, and I wish them all the best.
This has been a very fruitful session. I would like to thank both the parties for being so collaborative and forthcoming and having so hands-on approach to this issue. I hope your future relations will be very bright. Thank you.
I request the parties to
Thank you, both
proceed
the
with the closing
mediators
statement.
and the OEC for facilitating this session. This was a very fruitful session, and today's discussion has been a step forward in our shared commitment to rebuilding what was lost. The people of Gulf Haven have endured immense hardship, but they are still resilient. We appreciate the willingness of OEC to engage in this dialogue, and we look forward to seeing these commitments take shape through concrete actions, transparency, and accountability. With that in mind, we remain committed to collaboration and meaningful progress. As we move ahead, my counsel will say.
So first of all, I would like to thank the other party for being so collaborative throughout the session and understanding the needs of the people as well as whatever interest we try to put upon the table. Then I would like to thank the mediators for facilitating the session so well. Like when we began, your positive attitude made me confident that we will be reaching to a fruitful conclusion in the end. So as I believe that this session has demonstrated that a constructive resolution is possible when all parties come to the table with a genuine commitment to accountability and long-term solution. The agreements we have discussed regarding the compensation, the long-term plan, as well as the reputation will help us to rebuild the relationship which has been tarnished. And we look forward to formalizing these commitments in a manner that protect the rights of the affected communities and ensure sustainable restoration. Thank you.
Thank you, Vikram. Thank you, Sneha. Distinguished mediators as well, we thank you for the cooperation and for briefing us about the mediation process. OEC acknowledges the significant impact of the oil spill and sincerely regret the hardship it has caused. We have taken proactive steps, including cleanup, financial support, and collaboration with experts to address the situation responsibly. Our goal is to find a sustainable resolution through constructive dialogues and cooperation. We remain committed to restoring Gulf Haven and supporting its community.
First of all, I would like to thank the requesting party for being so cooperative about the whole session, and I would also like to thank the mediators for making this session so easily and smooth. We understand that restoration of the mishap has been more than an obligation for us as a company, and a financial compensation is not just a moral obligation. And we would like to assure you that OAC is full hands on fixing this problem and restoring the lives of the people of the Gulf of Haven. Thank you.
Thank you, everyone. I think we have summarized everything now. So, would you like to add anything?
I'm fine, and I wish all the parties best of luck for the future.
Thank you.
I think we can formally conclude the session.
It has been concluded. Okay. You want to conclude it?
Thank you, team, for giving us a valuable mock mediation session for our participants. They know I guess they have got a good insight. Now I'll be giving a general instruction about the competition, and at last we'll take all the questions which you have or queries, and we'll be answering it one by one. I hope my screen is visible. You can just show me a thumbs up if my screen is visible. Okay, great. So this is the 6th edition of S.K. Mishra Memorial International Mediation and Negotiation Competition. There are total 5 stages of the competition. We have 2 preliminary rounds, preliminary round 1, preliminary round 2. Then we have 1 octa-final round, 1 quarter-final round, 1 semi-final round, and next is the final round. So this is how the competition goes. Just a second, I guess this slide, it's working now. So we have in total 90 teams. So we have divided 90 teams into 2 groups, Group A and Group B. This is done so that you have a high expectancy to qualify into the other rounds. So Group A, 45 teams would be competing against each other. Group B, 45 teams would be competing against each other. We have then Group A's preliminary round 1, 2, and Group B's preliminary round 1 and 2. Further in the slide, you'll see the event itinerary. So you'll also know what timing does these preliminary rounds will be there. Next, out of that pool of 90 teams and divided into 45 and 45 of Group A and Group B, then for the octa-final rounds, top 16 teams would get selected from Group A and top 16 teams would get selected from Group B. In total, 32 teams would be there in octa-final rounds. Then after that, out of that 32 teams, 16 teams will qualify in the quarter-final round. So when I say 16, it means 8 negotiating pair and 8 mediators. And from there, we will have 8 teams in semi-final, that is 4 negotiating pair and 4 mediators. And then we'll have the final round between 4 teams, that is 2 negotiating pair and 2 mediators. Then this is the event itinerary. On day 1, that is 21st March 2025, we'll be having 2 preliminary rounds. Preliminary round 1 would start from 9 to 10:30 for Group A, and preliminary round 1 for Group B would start from 11 o'clock. And same preliminary round 2 for A and B would start respectively at 2 and 4 p.m. Then next day, day 2, 22nd March 2025, we have our octa and quarterfinal rounds, and the timings are given in the slide. Then third, we have third day, that's 23rd March 2025, we have our semi-final and final rounds, and then valedictory ceremony from 7 p.m. onwards, 5 p.m. onwards, sorry. Then after this is a basic timeline of the event. 1st March, that is today, we had the workshop of S.K. Mishra Memorial International Mediation Negotiation Competition 6.0. Then next in line, we have 5th March. That day will release the subsidiary rules and the clarification which we got from you all on the preliminary rounds problem. Then on 15th March, it is the last date of submission of plans, both mediation and negotiation plan. Further, we'll also discuss who will submit the mediation plan and how it has to be submitted, and negotiation plan respectively. Then 18th March, that is release of team matches. So on this day, you will get to know on which group you belong. So either you belong to Group A or Group B, and whether you'll be the requesting party or responding party, you'll get to know on this date, that is 18th March 2025. Then on 20th March 2025, we have a dry run session for you all. So since it's an online competition and it involves a lot of technicalities of Zoom, so we conduct a dry run session, which it's around half an hour session, where you'll be given a brief of how the competition work. And since you all know that the structure of the competition is that there is one negotiating pair from one college, second negotiating pair from a different college, and the 2 mediators are also from 2 different colleges. So in one courtroom, we'll be having total 4 colleges. So for the mediators to have a discussion or for how they want to take the mediation session forward, we have a they are called 15 minutes prior. So for all this thing, that going to the breakout room, coming out of that, how the caucus session would work, all the details, all the technicalities will be told to you on the dry run session. That would be on 20th March, the timing of which would be conveyed to you through the WhatsApp group and the Instagram and LinkedIn profiles of 𝐒𝐔𝐁𝐄 Mishra competition. Then we have 21st, 22nd, and 23rd March. That is our respective rounds: preliminary round 1 and 2, octa-final, quarter-final, and semi and final rounds. Then the problem release dates: the octa-final and quarter-final problems, mediation problems, would be released on 20th March, and the semi-final rounds and the final rounds problem would be released on 22nd March. So you need not to make plans for these problems. Plans you have to make only for the preliminary rounds. For these are only for the mediation session. So plans are not needed for these problems. Next, these are some general instruction for you all, that client and counsel can join from one screen, and mediators are allowed to share their screen. So this is for that they want to set the agenda through typing on the screen, or they can also use a chat box when they have to set the agenda, or any other use. The mediators can only share the screen. Then for the score sheet, it will take minimum 1 week. After the completion of the competition, you'll get the score sheet. And any decision of the organizing committee would be final, and it should not subject to any appeal. We also reserve the right to add detailed regulation at any time, as when we feel necessary. Then mediators have to join, since I have told this earlier also about that mediators, there are 2 mediators from 2 different colleges, so they need a discussion time, which is 15 minutes. So they have to join the rounds 15 minutes prior, so that they can have a discussion with the other mediators, so how they want to go about the whole mediation session. Then about the confidential information, so the preliminary round 1 confidential information would be released 1 day prior, that is 20th March, and confidential information of preliminary round 2 will be shared after the completion of the round 1. So, and accordingly for the octa after the result of preliminary rounds, and for quarters after the completion of octa final rounds, and further for all the rounds. Now, this is the main thing which you have to keep in mind, because it holds the marks which has to be added into your performance, and any wrong thing you can attract penalties. So mediation plan has to be submitted by the mediators. The document should be named as follows: team code, MP, that is mediation plan, pre-1 or pre-2, whichever the mediation plan belongs to. So one mediator has to make 2 mediation plans, one for preliminary round 1 and other for preliminary round 2. This is for the mediation plan. Mediator has to make this. Then next is a negotiation plan. The negotiating pair has to make it, that is client and counsel. The document name would be same: team code, NP, that is negotiation plan. Here you have to add whether it is requesting party, REQ, or whether it is responding party, RES, and pre-1, pre-2. So this is how you'll name. So there would be total 4 negotiation planned a negotiating pair has to make. 2 for preliminary 1, requesting party, responding party, and 2 for preliminary 2, requesting party, responding party. This is for the negotiation plans. Then next is the awards. So these are the awards which is mentioned in the brochure. So here we are specifying which awards would be given to which category. The negotiating team and runner-up best and negotiating team and the runner-up negotiating team would go to client and counsel. Mediator and the runner-up mediator would go to the mediator. Mediation plan to the mediator, negotiation plan to the client counsel, and opening statement of both mediator and negotiator. And apart from that, we have 4 more awards for the client and counsel, which involves best creative solution, acknowledgement of cultural differences, and so on. And then last, we have the best performance of first time participating team. This would be awarded to all the 3, client, counsel, and mediator. So this was all about general instruction, which I wanted to give you guys before starting of the competition. So if you have any questions, yeah, you can put forward, you can raise your hand, write it in the chat box. It would be entertaining. Yes, please. You can unmute yourself and ask your question one by one.
Yeah, am I audible? Oh, hello.
Yes, you are audible.
Yeah, perfect. So basically, I wanted to ask few questions regarding the, see, I wanted to know whether the first mediating problem, the first the problem proposition that you sent us, right? They said that they filed the respective divorces in India and Italy. So I wanted to know whether I wanted clarification whether if it's in Italy, whether if it's in India or Singapore, because majority of the assets and all are dealt in Singapore there. So I'm not so sure whether the mediation is happening in India or Singapore.
Okay, so actually, this is a clarification which we have raised to the person who has drafted the problem. I guess you all have put up a lot of question in the clarification form which we had put it in the group. So we had sent all the question to the drafter so that they can answer all the question. And on 5th of March, you'll get all the answers and the queries related to mediation problem. And what question you asked, that whether it belongs to the Singapore or India, everything would be answered there in the clarification document.
All right. My next question is, out of the 45 teams, you said that 16 teams would qualify, right? But then your semifinals team will consist of 8 teams.
Yeah.
I'm not so sure how would that be possible for the finals. So could you just
Okay, so
clarify
here,
that?
when I said 8 teams, since in one courtroom we have 2 negotiating pair and 2 mediators. So for a final round, for one mediation session, we need 2 negotiating pairs and 2 mediators. That is why I said 4 teams, because everyone belongs to a different colleges.
No, but
yeah.
It can actually so happen that the requesting team or the responding team's mediator may qualify till the finals as well, right? So
Yeah.
in that situation, it would be 3 teams then.
That situation, it would be 3 teams. But in general sense, for keeping a flow of the event to make you understand everything, I wrote it 4 teams. The exception obviously happened because the client and counsel, that is the negotiators' score sheet, would be very different and mediators would be scored differently. So it can happen that from the same team, the client and counsel and the mediators go forward in the competition and they can reach up till the final. So in that case, the teams would be 3 in sense of colleges. But in general, it's 4 teams. That is 2 negotiating pair and 2 mediators.
So when we just understand from the perspective of just the client and the counsel, right? So you're saying only 8 teams from the 45 will qualify, right?
No, I said...
No, just the client and the counsel. Just the client and the counsel perspective, only 8 client and team counsels will qualify for the octa rounds, right?
No, not 8. From 45, 16 teams would qualify, and from Group A and from Group B, 16 teams would qualify. So in octa final round, total of 32 teams would qualify. That is, you can divide 16 negotiating pairs and 16 mediators.
So yeah, that's the point, right? So 16 teams from both the events, both the groups will qualify as negotiating.
Yeah.
Just the negotiating pairs is basically 16. Perfect. That's it. Yeah.
Anyone has a question? We'll also share you this PPT in the WhatsApp group. And also, if you are not added in the WhatsApp group or your teammates is not added in the WhatsApp group, you can connect with us and get them added. We have also shared you the WhatsApp group link, because all the communication from now on, whether it's related to confidential information, mediation problem, or anything, it would be dealt with the WhatsApp group. So you must be added there. Anyone has any question? Ashpinder, do you want to ask anything? Yes, Riyansh.
Will there be a separate team group for every team, or like we'll be appointed a TR, or there will be only a general group for the same?
But share some point of contacts for you so that you can contact if in case you are facing any queries. So we'll be sharing some 5 to 6 members number so you can contact them.
Okay, so we will not be appointed any TRs, like there will be a general contact on your part.
Yes. But if we feel that there would be a lot of like administrative thing, then we'll appoint a different POC to different team codes.
Also, one more thing I wanted to ask you was whether can we give any written submissions during the mediation rounds itself?
Written submission in what sense?
I mean, for example, let's take the cultural differences or the educational between different two countries, right? Can we like provide statistics to substantiate our proposals on that matter?
Client and counsel cannot share their screen. So if you want to show the document, you cannot show it. Rather, you can refer it in a way. If you want to refer it in the mediation process, you can do it, but you cannot show it to the mediators or the other party, because only mediators are allowed to share their screen. That is only for setting up agendas or if they want to note the points.
Done. All right.
Anything else?
So a basic follow-up for the question that was asked, like if we will refer to the particular document in the session, so how will be the viability of the document be checked by the mediators or the other team if it is not shared?
See, I'm not saying refer in that sense. I'm saying if you want to take some insights from the document, you can do it. But for our purpose, because for sharing also, we need to give you rights. For share, all the participant cannot share. So that is why we have kept it only for the mediators, just so that usually they don't do it. Usually they write things in the chat box only. So if you want to do that thing, what you can do that you can share the link of the document in the chat box so that the mediators can view it if they wish to. This can be an alternative for you.
Okay, so we have to create a link for the same document and then we have to share it in the chat. So, okay, thank you.
Anything else? Okay, then thank you so much, everyone. You have been a wonderful audience and being here and experiencing the workshop and the wonderful speakers who came today. So thank you so much for being here. If you have any queries, you can mail us or you can contact us. We'll be providing you some numbers who can be your POCs. Okay, thank you so much.